What's up, everybody? Net Narrator here once again for some more Epstein stuff, and we are starting with dataset 7. We have done dataset 6. I can't believe we've done dataset 6. I have no idea. I almost don't believe it myself that we've done dataset 6. I'm actually going to check to make sure it's actually right. I probably should have done that beforehand, though. Almost hard to believe. I'm pretty sure I've gone up to 9,000. Yeah, I did. And it ends at 9,015. The reason why I say that is because this is 9,016, and it doesn't have any kind of tangible introduction or anything along those lines. It is literally just page 200 of something. So we're going to get back to that in a moment. But for now, of course, I fully intend for any proceeds gained from this content and my other Epstein coverage to go to Speak Out, Act, Reclaim, SAW, which is founded by Virginia Goffrey, who's now deceased. And while the organization is not currently accepting donations, at least public donations, and I was unable to set up any official fundraiser via YouTube, I will donate the proceedings when possible, or to a similar organization if not, and proof of this will be released when I do so. So yes, dataset 7 out of 12 datasets. However, not all datasets are created equal. There are, this is file over 9,000, memes, but there are apparently several million, and there is tens of thousands to go, if not, 2.5, 3.5 million, I think the files was. But I do understand there's a lot of redactions. So we'll see if we get any heavy redactions with this. But on the plus side, we do see a massive wall of text. Now, the total amount of files in dataset 7 appear to be around 600 files. That said, from what I've seen, they are 4 pages of text. This is page 300, so this is the same document as this. But why we're starting on page 200, I don't quite understand. I don't know what the context is. I'm sure we'll find that out as we go along. I don't understand why we have not started on page 1 rather than page 200 here. There's 200 pages before this. Where is it? Is it in order? It's been placed in order by the Department of Justice. I have double-checked on the Department of Justice website. The file immediately starting dataset 7 is this right here, and it goes 200, 201, until 300 on this next page here. So yeah, but it could be that, for example, this is page 101, so it could just be it's just completely out of order. If this is page 200, we're actually going to double check. I'm actually going to scroll to the bottom. Pull the plug at any time before it was signed. Clearly by the morning of that day, you were calling for some more edits that really seemed to reflect a real discomfort. Okay, so logically speaking, file 9,329 precedes that of 9,016. And you know what? I am ready to do this in order. Let's put that there. This starts at file 101. Then this goes for 200, and this is 300. This says page 1. Now, let's get to the bottom of this PDF. Oh no. Let's get to the bottom of this. Is what I think it is. You got videos accounting reflecting in Exhibit 8 from redacted of the different Jane Does. There were a lot of them, and there were many counts in this indictment, and many... and many carefully. Each victim was tied to a particular set of criminal activity. Yes. Okay. So I think this is the correct order of these files. Now, there could very well be a lot more. Let's see. Okay, it ends page 412, and this is the end of these files. So yeah, we've got... How much was it again? 412 pages of just whatever this is. So yeah. I'm ready for it. Let's do it. Let's get ready. Because I'm going to do this in not the order as they appear in the files. It appears that this is being scrambled around a little bit. But it starts, the file called 9229, then 9329, then 9016, then 9116. So this is the correct order. It's not being done by the Department of Justice. I'm going to do this completely in order. I'm not sure if I'm going to be able to get it done within the same stream. It is over 400 pages. While I've done some madder shit before, it's 9 o'clock at night. I've been recording all day. It might be that my voice goes beforehand, at which point I'll just cover this over 2 streams. But this looks clippable, so we're going to see. Anyway, zero viewers. Hey Flint, how are you doing? I very much appreciate it. But yeah, people will naturally just come in, watch the VODs. As I say, these Epstein file readings aren't massive draws, because I can imagine it's as tedious to watch as it is to read sometimes. So, it might be I slow things down. I'm still determined to do the entire lot, but I might also mix a few entertaining streams in the midst. You know, just to get people, interested, watching, whatever. Get a little bit of a morale boost for myself. But yeah, we'll see how it goes. But yeah, I mean, maybe we'll even have a cat showing up. Unfortunately, nope, that's not Dexter. I thought that was Dexter. We don't have any cats visiting us today. We may have a close-up shot of Clara or Dexter. They're currently eating their dinner. So, let's make a start on this. I mean, this isn't even the entirety of Dataset 7. It's 412 pages of this exact same thing. We're going to find out what it is. So, brace yourselves, boys. Fucked up already. The United States Department of Justice, Office of Professional Responsibility. Interview of R. Alexander Acosta. Washington, D.C., Friday, October 18th, 2019. Interview of R. Alexander Acosta, a witness of lawful age taken on behalf of the United States Department of Justice in the above entitled action, before Beth Roots, Notary Public in and for the District of Columbia, in the offices of the U.S. Department of Justice, 950 Pennsylvania Avenue, NW, commencing at 9:34 a.m. Diversified Reporting Services, Inc., redacted. So this is apparently a witness. Are they a member of staff? Don't currently know. Certainly it's not Maxwell, so it'll be, hopefully it'll be a bit better reading than any of Maxwell's interviews, because I fucking hate that bitch. I will just go straight up and say it. I have grown to hate Ghislaine Maxwell a lot more than Epstein, because we still have Ghislaine Maxwell, or at least you guys in the US have Ghislaine Maxwell, and she's not naming names. She is refusing to cooperate. So, I guess it's harder to hate Epstein just because it's dead and we haven't had, transcripts with him specifically yet. But Ghislaine Maxwell, we had a few in 2024, and goddamn, I really grew to hate her. Anyway, speaking of hating, we're already on page 2 now, so I better get a move on. Appearances. On behalf of the Department of Justice, redactions. Department of Justice, 950 Pennsylvania Avenue, NW, Washington, D.C., 20530. Redacted. On behalf of the witness, Gordon D. Todd, Esquire, T.J. Heron, Esquire, Sidley Austin, LLP, 1501 K Street, Northwest, Washington, D.C., 20005. Redacted. Proceedings. Whereupon, R. Alexander Acosta was called as a witness and, having been first duly sworn, was examined and testified as follows. Examination by Ms. Redacted. And I'm not going to say QA for each, even though it's done in this format. I'm also not going to say the numbers on the side. To differentiate the questioner and the answerer and the lawyers, I will just use different voices, and that'll make things quicker. So, would you tell us your name, please? Renee Alexander Acosta. And Mr. Acosta, you're accompanied by your attorney, Gordon Todd, is that correct? Yes, it is. And Mr. Todd, would you identify the associate you have with you? It says Mr. Heron. Yes, T.J. Heron. Misredacted. Ain't she R-R-O-N? Mr. Heron. Correct. Misredacted. Thank you. Mr. Acosta, I'm redacted. I am a counsel with the Office of Professional Responsibility here at the Department of Justice, and with me are my fellow OPR counsel. Redacted, redacted, and redacted. We are in a conference room at the Department of Justice main building on today, October 18, 2019, and we're starting at about 9:30 in the morning. Before we start, I just want to put on the record that Mr. Redacted worked in the Civil Rights Division at the time that you were the AAG heading that division, and I believe had an occasion to briefly meet you in connection with a matter. The witness. Could I ask what section? Mr. Redacted. I was in the Special Litigation section. The witness. Oh, okay. Mr. Redacted. And I provided Mr. Acosta some talking points for a press situation that we had in that case. The witness. 14141. Mr. Redacted. Yes. The witness. Probably. By Ms. Redacted. All right. Thank you. Mr. Acosta, OPR is investigating two things. As you know, one, whether one or more federal prosecutors in the Southern District of Florida U.S. Attorney's Office may have committed professional misconduct by entering into the Non-Prosecution Agreement, or NPA, in 2007 with Jeffrey Epstein, who at the time was under investigation by that office and the FBI for engaging in widespread sexual misconduct involving underage females. The second thing we're investigating is Judge Mara's finding of February of this year, 2019, that the government may have violated, or actually, he found the government did violate the CVRA, or Crime Victims' Rights Act, when it entered into the NPA without first providing the victims with notice and a reasonable right to confer with the government. You are a subject of the OPR investigation. That is, one of somebody whose conduct is being reviewed and evaluated by OPR, and specifically as U.S. Attorney at the time for the Southern District of Florida, you had the ultimate authority over the Epstein for a period of 2.5 years, as we understand it, from the time the line AUSAA redacted first briefed you, and then criminal chief redacted in the July of 2006, and until you were formally recused from the case on or about the 8th of December 2008, after notifying the Executive Office of the U.S. Attorneys that you were seeking employment with Kirkland & Ellis, a firm of which two attorneys, Ken Starr and Jay Lefkowitz, had been representing Jeffrey Epstein. Is that correct? Ooh. So this is the head lawyer that got Jeffrey Epstein, well, not punished severely enough back in 2007, which is when he was first imprisoned for, I think, 1.5 years. And, yeah, it should have been longer. And apparently these people agree. Oh, excuse me. We may get into it a little bit later, but I think the characterization of my seeking employment is not accurate. We can talk about that a little bit later. All right. We have the documents that relate to that. So that's what we're basing it on. Correct. And I believe the term that's used is seeking employment. That is the term used in the email. I think I addressed that I believe Mr. Todd addressed that in the letter that was sent to... All right. OPR. All right. Thank you. So we recognize that you're no longer with the Department of Justice. Right. And that it is your choice to come and talk with us, and we very much appreciate your willingness to voluntarily do so and help us figure this case out. OPR provided you with a few thousand pages of records, emails, and correspondence, and some other documents that reflect your involvement in the Epstein matter over that 2.5-year period. Now that you've had a chance to review, I hope, those emails and other documents, we hope you can be specific in helping us understand what happened. Have you in fact been able to review these documents? Yes, I have. Thank you. OPR asked you for a written response to certain questions. We received and reviewed a written response prepared and submitted not by you, but by your attorney, Mr. Todd, on your behalf. Have you reviewed his response to, yes, you? Yes, I have. And will you now under oath subscribe to that response, as if you had submitted to it yourself? So, Mr. Todd spoke to me and conveyed the investigation that I provided him. I believe he conveyed that information accurately, and the statements that he ascribes to me in that letter I believe are accurate. All right. Do you have any changes or corrections to that written response? No, I do not. Is there anything in it that you do not agree with? Again, I think that the statements that he ascribes to me are accurate, and I agree with them. All right. So we are going to accept that statement as representing accurately what you would have responded if you had responded to us directly. Is that correct? I Yes, the statements. He basically gives my positions, and I believe that he gave my positions accurately. Perfect, thank you. So as we ask questions and refer to documents, we would like you to correct any misstatements in our questions, or any misstatements or errors that are in the documents themselves, because we want to make sure the entire record is correct. Also, there's been an enormous amount of publicity about the Epstein case, particularly this year, including about the events and decisions made back in 2006 to 2010 that are the subject of our investigation. And so, as best you can, we ask you to try to answer today from your knowledge, understanding, and recollections as of that period of time. However, to the extent you are asked or do speak retrospectively, we'll just make it clear that you're doing so. Alright, okay? And if I could just say, one of the difficulties is... Oh, my Streamlabs appears to be buggered. There we go. I'll redo that. And if I could just say, one of the difficulties is with everything that... all the publicity and all the documents that are made into the press and in litigation, distinguishing between recollection versus after the fact. Right. Speculation. And I will try, but I would appreciate reminders along the way, because it's an important distinction, but it's kind of hard sometimes. We recognize particularly the importance of it. Right. That's precisely the heart of, our matter. So, Mr. Acosta, your professional background is a matter of public record. I have a couple of questions. By what state bar are you currently licensed? So, I am inactive in Pennsylvania and also in DC. Alright, and not in Florida? Not in Florida. So, do I understand that you are not currently an active member of any bar? Guys, chill. Not sure if you picked that up, but I've got the kitties running back and forth. So I've no doubt they'll tire themselves out, and they'll eventually come up and say hi. Yes, here we are. I would have to confirm with DC. I said not inactive in Pennsylvania and in DC because I am not certain whether I'm currently active or inactive in DC. I am not currently practicing, and so I would have renewed under either active or inactive. Alright. And we can verify that and get that. They're talking over each other. We would appreciate it if Mr. Todd could let us know your current status. I also would like to know your bar status in the period of 2006 through 2008. Do you know what that was? Most likely, I can speculate. I don't know as a fact. Most likely active in DC. And inactive in Pennsylvania. Okay, but likely active somewhere, correct? Yes, I think that's a requirement. Yes, that is requirement. So, it would be DC. The distinction between active and inactive in DC is more minor, as I recall, than Pennsylvania, where there's a large fee difference. Alright, thank you. And we look forward to hearing confirmation of that from you, Mr. Todd. So, after serving nearly 2 years as the Assistant Attorney General in charge of the Department's Civil Rights Division, you were presidentially appointed the Interim U.S. Attorney for the Southern District of Florida in June of 2005, and then, as we understand it, you were formally nominated as U.S. Attorney in June of 2006, and after being confirmed by the United States Senate, you were sworn in by the U.S. Attorney as U.S. Attorney in late October 2006. So yeah, this guy this 412-page interview, this is the guy that was the head honcho for the district when the Epstein stuff came about, and though they pursued the investigation, they got Epstein, they arrested him, they found him guilty on these charges, they let him go early. He served 1.5 years, I think, in prison, 2007 to 2008, and then for some reason they let him go. I think the official reason was of Epstein cutting a deal, but I am unsure. That said, investigations into Epstein were reopened because of the very light sentence he received. So, and obviously the stuff that he went on to do, because this is just the tip of the iceberg. He apparently did some worse shit, which we know, Epstein Island is famous for a reason. And apart from the photos earlier, we haven't had any interviews, transcripts and stuff about Epstein Island, or indeed the Zorro Ranch. Most of this is covering the Florida investigation in West Palm Beach, and also some stuff in New York as well with his New York address, because, it happened over there as well, and Florida witnesses are confirmed to have travelled over there. So yeah, we'll carry on. This is going to be very interesting. I think that may be inaccurate. I would have to confirm. When you say presidentially appointed, I believe it may have been appointed by the Chief Judge at the request of the Attorney General. The Chief Judge has appointing authority. Okay. And you'd have to go back and confirm whether it was either an AG designation or the Chief Judge. Alright. Which is different than presidential. And I understand. And again, I would appreciate if you could, follow up on that. I'm Mr. Todd? Not certain how to confirm that. That's something that in all candor the department would know. Alright. Much better than I. Then we will pursue it. My point is that there was a change in your status from interim to you, the U.S. Attorney, with the full correct confirmation. How, if at all, did that change in status affect your view of and your exercise of your authority as U.S. Attorney? So it's difficult to recall. You're now asking that just 10 years back, but even further back. I was interim for a sufficiently long period of time that by the time the change in status took place, I would speculate that I was, in my mind, acting as U.S. Attorney, whether you have an adjunctive interim or acting in front of your name or not. I had great people. I don't recall when Redacted came on board as first assistant, but he was my crim chief, and I thought for the continuity of the office, it was important to promote him to first assistant, and he was promoted actually effective October of 2006. You made a series, according to emails. The personal announcement was made to be effective in October 2006, naming Redacted as criminal chief and Redacted as first, assistant. Oh dear, my voice is breaking already. Pardon. Sorry, I ate dinner before I did this. That was a bad idea. Right, and they were both long-serving professionals within the office, and basically, as my recollection, everyone just moved up one rung. Okay, you know better than I, because you have those records, and so, sitting here today, I don't recall any specific way in which that shift would have impacted. Alright, my thinking. You had not served as a prosecutor before, and didn't have direct criminal experience, is my understanding. That is correct. I had supervised civil rights, for example, had supervised criminal prosecutions, but I had not been a line prosecutor previously. So as the US Attorney supervising a couple of hundred, line prosecutors, most involved in criminal work, what interested you most, or appealed to you most as you undertook and carried out your duties as US Attorney? What interested me and appealed to me? So, the work of the office. I mean, it's a broad question, but the work of... That office and any US Attorney's office, I think, is incredibly impactful to any local community. And I very much enjoy being a part of the effort to bring folks to justice, to move policy initiatives. I recall early on, we identified healthcare fraud, as one big area, and we had one of the largest out of the largest healthcare fraud initiative. We focused quite a bit on gun violence, and we did a great job on that. Guys, shh. And we did a great job on that, and it's one of those jobs where people feel very good about what they do, and it's great to be part of it. I'm sure No, that's... Okay, that's helpful. It just gives us some perspective. Yeah. Was there any aspect of it that you particularly disliked? To the extent you're dealing with personal issues, I think personnel issues are really the preferred part of any executive function. You mean the conflicts among attorneys, things like that, or performance issues? Performance issues. Alright. And when you've got... In any large office, you get personal issues, disciplinary issues, and those are never... Those are never fun. So we talked about the professional. High-level personnel changes you made sort of after your first year there. Redacted had, we understand, been functioning de facto as a first assistant, while Redacted was not. We understand Redacted had been first assistant, but he stepped away, and Redacted came in to essentially take over his brief until he was formally appointed first assistant. Is that consistent with your memory? So you might have characterized that more strongly than I would have. Okay. Again, it's difficult to recreate from back then, but there was certainly a transition period from Mr. Redacted to Mr. Redacted, and if I could, because when you said high-level changes, my intent... It was a great office, great professionals. My intent in elevating Mr. Redacted was just, you go from criminal chief to first assistant, and I don't recall Mr. Redacted's prior position, but I know that he was also elevated. I think he might have been major crimes, but that's correct.
I'd be speculating. I could guess it. We can verify that. Okay. Yes. What was your assessment of Redacted? His capabilities, his judgment, and his working relationship with you on a day-to-day basis? Outstanding. He had been in the office for decades. He was respected by everyone. He had a good tone to him. He was someone, I wanted individuals around me that were respected within the office, and that were trusted, and that had been there for a long time. And then I think I was very lucky to have that in my management team. As we understand it, your office as US Attorney was sort of on one side of the reception area, and the First Assistant's office is on the other side. Is that correct? That is correct. Or, at the time, correct. That was correct. So did you and Redacted have a sort of easy back and forth? Walking? Open door? Into each other's offices multiple times a day? Alright. Kind of relationship. Alright. And given that he had experience throughout his career as the department in the criminal arena, and you had not, to what extent would you rely on him, among others, for guidance, perspective, information, and so on? I named him First Assistant because I valued his guidance and his perspectives, and I thought those were valuable. Okay. You also, as we pointed out, appointed Redacted to succeed Redacted as Criminal Chief effective October of 2006, and he served for about 10 months before he left for private practice. He left at the beginning of August. 2007. What you did... You said you didn't recall, as we said here today, what section he'd come from. Right, I guessed it was major crimes. Alright. What was your assessment of Redacted? Outstanding as well. And if I could say, when I say I don't recall but I guess, when you're going back 12 years, sometimes you get an impression but you can't say it's a recollection, and that's going to come up multiple times today just because it's a while ago. As long as we make that distinction, right, both are helpful. Right, and so whether it's a recollection or a construction after the fact, I can't say, but, I thought that one of the helpful factors with Redacted is he has spent a lot of time, and Major Crimes is the most active unit. I assume you all know the structures of the office. But Major Crimes is not Major Crimes. It's sort of the entry-level crimes, and I valued the fact that he had trained and, so many ASAAs, and really spent a lot of time reviewing the Major Crimes Chief as opposed to the other chiefs spends a lot of time reviewing the work of ORSAs, and so he'll be someone who is very experienced and able to get in the weeds. And he, in fact, was around during that time period, had gone back in the courtroom, if you recall, to actually try a major case. Do you recall that? It was I didn't until you... Major fraud case. Mentioned. I didn't until you mentioned it, and now there's something in the back of my head that's saying that sounds right, but I can't give you more detail. Alright. What was your assessment of Redacted sort of working style, and particularly working with you? Again, positive. I didn't see him as often as Mr. Redacted, but was he located on the same floor? He was located on the same floor, but not within the same suite. And that affects interaction, but a positive working relationship. Alright, and how, to what extent would you, as criminal chief, was he relied on by you as distinguished from Redacted with regard to the criminal matters pending? Also relied on, that would depend almost on the matter for, as in a typical situation. He would bring things to Redacted, who would bring them to me along, and so he would bring things to Redacted, and then depending on their discussion, they might both walk into my office, but he would typically run things through Redacted before coming to me. Were there occasions when he would come to you directly? Sure, that's why I said in a typical, It's difficult to sort of recreate the interactions, but he certainly could come to me directly, and in some cases, I would say probably would. Again, it being a large office with several physical locations, as we understand it. A very high volume, of cases. Right. And particularly in the criminal context, is it fair to say you didn't review every prosecution as it was brought? It is not just fair, but accurate. I recall a conversation with a US attorney from a small district early on at one US attorney's conference where we compared notes, and the interaction of an office with 30 prosecutors is very different than one with, a few hundred prosecutors. So, when you did engage on a criminal case, would you, whether it was a planned prosecution or a case heading to trial, would you generally rely on written submissions, or would you... This is really an inquiry into, right, your style. Or would you have everybody together and talk about it, or would you rely on your most immediate subordinates to be briefing you? Which one of those? So, approaches, did you take? I would say that really depended, and probably varied based on individual needs. For the most part, I would most likely just speak with my first assistant and or criminal chief and assess what else needed to be done. In other words, you would sort of do it on a verbal or based on oral, correct. Interaction and correct. Presentation as opposed to going through stacks of papers. I would say that was typical. Yeah. I don't want to say that was the case every single time, but that was typical. Alright. And to what extent did you go out and about to encounter the line attorneys, for example? Was that something that you were able to do and wanted to do? Yes and yes. And when I started, I made it a point of walking every floor and meeting everyone, and toward the end of the day, I would also, if I could just make it a point, particularly of major crimes, of just walking down to the floor and seeing who was there and what they were doing, and sort of popping my head in and just saying hi because I think it's the right thing to do. Okay. Was that a way to support the troops, or was it more a way for you to become informed about what was going on? Probably a little of both, of support the troops, but also get the temperature for the office, see how matters are progressing. You at the criminal, or rather the civil rights division, had experience with human trafficking and child sex trafficking cases. Correct, under your supervision. We understand that you brought that concern, or your concern about those issues, with you to the U.S. Attorney's Office, and that we know that under your tenure, the U.S. Attorney's Office had many successful prosecutions involving conduct ranging from internet child pornography, to international sex tourism. Correct. Victimizing children in particular. In mid-2007, you, according to press reports, you set up a new Special Prosecutions Unit. Correct. To focus on, among other things, sex crimes against children. Could you tell us what importance those kinds of cases held for you as U.S. Attorney? Sure. If I could just back up a little bit, because the question goes, the Special Prosecutions Unit, and let me address that part of it. There are a few things embedded in that. There's the Special Prosecutions Unit was set up because there were some issues that I thought were important to pursue in particular. And one of those was sort of the trafficking issues. Another one was the gun violence, and the intent of special prosecutions was to have a group of individuals that would sort of be dedicated and not be part of the usual major crimes group. So it wasn't exclusively... Your question may have implied it was exclusively for sex crimes, did it? Oh no. And it wasn't. Yeah. No, I understand it was not. Right. Okay. And so I thought it was sufficiently important, and so it was one of the initiatives that we were certainly pursuing. And was that something to which you brought your experience as head of the Civil Rights Division as well? It was. I think I know when I was head of Civil Rights, so that's something that I put particular emphasis on, and I thought Civil Rights really stepped up and did a great job on that. Did you yourself ever... I recognize you were never a prosecutor as such. Right. But did you ever have experience being involved in a prosecution that... sort of the nitty-gritty of the prosecution of that kind of case? Sort of seconding yourself to a trial team, for example, or an investigation? So if by nitty-gritty you mean seconding myself to a trial team, the answer will be no. Alright. There are a number of cases that I recall being briefed on and talking about, but at that high level? Correct. Alright. The department set up in 2006 a PSC program, a Project Safe Childhood program. Correct. Focused on internet child pornography. And you appointed Redacted as your first PSC. Correct, coordinator. And she was also, of course, the line attorney on the Epstein case. How well did you know Redacted, and can you give us your assessment on her capabilities, judgment, and her interaction with you? So, a few things in there. How well did I know her prior to appointment? I don't recall. I don't think I knew her particularly well prior to appointment. She was clearly respected within the office. Hello, Dexter. And I don't recall, but I can speculate that she was appointed based on recommendations of management, and her interest in some combination, and prior work and some combination thereof. You asked me to characterize Redacted. Your view of... Right. Her capabilities, her judgment. Right. Her acumen, her knowledge of the law. I think she was a good, strong professional also. I mean, did you have any negative, anything less than fully positive in your assessment of her? No. Okay. I think she was a good, strong, dedicated author. All right. Redacted, yeah. was the managing author at the West Palm Beach office. Correct. At least. And Redacted worked there. How closely did you work with Redacted? And again, that assessment question. Right. What was your assessment of him? So, less so, only because of geographic distance. I would also say he was a respected professional. He had a good reputation. He went on to be chief of staff here at the criminal division, which I think speaks to how he was viewed within the department. And so I would say positive. Okay, so now turning to the Epstein case. Yeah. Now that your recall has been refreshed by virtue of the documents we provided, before we get into the actual sort of documents and some of the details of the events, would you please give us a general overview of what you currently remember, refreshed, about how the case came into the US Attorney's Office, how it was assessed for prosecution, and how and why the decision was made to resolve it with a 2-year state plea that ultimately became an 18... Okay. I mean, yeah. A 2-year state plea that ultimately became... Alright. An 18-month state plea. Okay, so... Mr. Heron. Before you answer the question, let me just jump in on the notion of refresh your recollection, which is, of course, has a very specific legal meaning, and I think to assert that Mr. Acosta's recollection has been refreshed generally probably overstates it. It's really a document-by-document, issue-by-issue thing, so I push back on that. Misredacted. Mr. Heron, a little bit, but the question is fair and accurate. Misredacted. If you're talking about handing him a document to refresh an exhaustive recollection, that's not the process we're talking about. We're using it in a more lay term that, if we asked you this before, giving you all these documents, you'd probably would not been able to be as full in your responses. So we're asking for your full response. Thank you. Mr. Heron, we appreciate the opportunity to review the documents, and Alex, in your answers, try to distinguish what you actually recall. The witness, yeah. Mr. Heron, in your own head versus what you saw in the documents. Misredacted, yeah. Mr. Heron, and that would make for... Misredacted, thank you. Mr. Heron, the cleanest record. The witness, okay, so 3 parts. How did it come into the office? By misredacted. How did it come in? Right. How was it assessed for prosecution? Right. And then how and why the decision was made, right, to resolve it the way it was. So, let's begin with how did it come into the office. Putting all the documents aside, I can't say with certainty how it came in. I can speculate how it came in. The way it would have come into the office is... Oh shit. I can't say with certainty how it came in. I can speculate how it came in, and the way it would have come into the office is... I can speculate that the chief rider from Palm Beach County would have brought it to either the FBI or to the Palm Beach office. I'm not certain that I would have asked who brought this case to the office, as opposed to the case is now in the office. So let's discuss it, right? The format, or the mode in which it came in, I think is important, because my recollection is it arrived to us in the position that the state attorney had negotiated a plea, and that the reason that we looked at it was that the plea was going to be that there had been an initial charge that wasn't pursued, and that required jail time and registration, and that the plea that was going to be taken was a charge that didn't require jail time and didn't require registration, and based on the preliminary assessment of the facts, that seems wrong. So that's how did it arrive. The next question was, how is it assessed for federal prosecution? So it was assessed for federal prosecution, my recollection from very early on, and I'm sure we'll talk about this some more, is you have a case that, well, technically it wasn't final at the state level, but for federal involvement would have been final, and so from the earliest point we were thinking federal versus state and petite, and the contemporaneous record sort of shows, at least the material that I got, the earliest communication was Mr. Redacted telling me that Redacted is preparing a petite policy waiver. That Ms. Redacted is preparing a petite policy waiver. And that's consistent with my recollection of how it was assessed and then brought in. Assessed, Does it make sense to go forward? Yes. Investigate and circle back. And then the third part was the how and why the disposition. So my general recollection is the view was that if the state had followed through on an original charge, I don't recall which, that called for jail time and that called for registration, that the local police or whoever brought it would not have seen the need to refer it. And so that was in terms of pre-indictment resolution, a logical and reasonable place given all the other sort of factors, both the petite concerns, the witness concerns, and the legal concerns. And to that, I would add a fourth concern, which is it had already been reviewed by a grand jury at the state level, is my recollection. And so to some extent, that's indicative of how some individuals may sort of view this matter. Okay, we're going to pick that apart. I figured. But thank you for that. You asked for an overview, so I tried to be very, general. The second part of that last prong was why a 2-year state plea? In other words, you talked about assessing the case and why resolve it, but why with a 2-year state plea? And so, overview. And so my general recollection is, my understanding, if I was asked, what is the best understanding that I have of why 2 years, is what would have been obtained in one of the original state charges. Again, this is, how do you know that? How did you know that? That's why I say general recollection. I'm reconstructing memories of that 12 years ago. I can speculate that at some point the matter came up and I or someone else said what would the original plea have, what would the original charges have likely brought? And someone said this amount. How would have said that? I'm speculating at this point. I don't have a recollection, but that's my general understanding. All right. Well, now unpack. Some of that. I noticed. And by the way, my colleagues, we're all in this boat together. So they're going to feel free to, chime in. As they see fit. So the first thing going to the intake of the case, we know from the records that, and by the way, we've obviously done a great deal of other investigation. Right. And spoken to many people. So, redacted, briefed you, and redacted pretty much when the case first came in. In mid-2006, after the FBI, and indeed the office, the US Attorney's Office in West Palm, had opened the case, but before Epstein was indicted. So, this first exhibit number 1, that you have in your binder before you, or in your folder before you, is that email from Redacted to you that you just referred to date July 24th? Right, 2006, in which he's sort of passing on the information that Epstein has by now been arrested and indicted by the state. Or indicted? Do you recall anything about that original briefing from Redacted? I don't. Alright. Did you know at the time she briefed you, which is prior to Exhibit 1, did you know who Epstein was? I did not. Never heard of him, to your knowledge? To my knowledge, I don't recall having heard of him. And what did you understand at that early point the case to be about? So, I don't recall the briefing, and so I can't give an independent recollection. Based on this, you're talking about Exhibit 1, and you're based on Exhibit 1. I can infer that this would have been my general understanding of the case, and the key things that I point to is pre-trial diversion, which is code for no jail time, and petite policy. But this, Exhibit number 1, right, does not make it clear to you that this case involved allegations that Jeffrey Epstein had been enticing, coercing, whatever verb you want to use, young underage females. We will, for the record, call them girls here. As opposed to women. And these underage females were being paid to provide him essentially with sex or sexual activity or conduct of a pretty salacious nature. Do you recall that as being essentially what you were briefed on from the beginning? Sorry, I'm just going to turn off this side light here. Partly because it's annoying the cats. Partly because I'm having trouble reading the chat. Yes, As opposed to women, and these underage females were being paid to provide him essentially with sex. Oh, no, pretty salacious nature. Do you recall that as being essentially what you were briefed on from the beginning? Okay, I think that's the end of that bit. Okay, I'm just going to read the chat real quick. Sorry, I've neglected this. I've been locked in with this. Page 35 of 412 of this entire little saga, but this is really interesting. I've got to carry on. Good evening. Hello, Aaron. Did you get a haircut? Absolutely. I was going to make a joke about wearing a wig before, but no, I got a haircut. I don't know if I think it wasn't yesterday, it was the day before. It needed to be done, long overdue, and
To be fair, the barber was of questionable immigration status, but he was so quick, and he got it done. Like, he took, like, I swear he took less than 10 minutes. Got it done really well, and yeah, and that was it. Big Stein was spotted at Tel Aviv yesterday at 2:48 p.m. I mean, that keeps getting mentioned. You know, I'm just going to say, let's see the photo, let's confirm it's not AI, all of that kind of stuff, because, you know, that joke has been done to death. But I would say, you know, where's the body? What happened to the body? Can we get DNA evidence? But anyway, yeah. I hope you guys are doing alright, but I'm going to try and lock in as much of this as possible. If I can get the entire lot done tonight, I will, but I suspect that might not be possible. I'm close to 10% of the way through this little bit. He's the new Elvis Presley. Again, I don't recall the initial briefing. I take it based on your review that there was an initial briefing. I can't say the degree of detail. I can't say what it was about. As a typical matter, I wouldn't be briefed when a case comes into the office, other than being made aware this is a case, this is what we're looking at. So then understanding you don't remember the briefing, is it fair to say that you did have some understanding of what the case that was that West Palm Beach was pursuing as of mid-2006? I certainly had an understanding of the general facts of the case early on. I can't speak to whether it was mid-2006 versus late 2006 versus 2007, but early on. I certainly had an understanding that it was a case that involved, you know, a billionaire who was doing sordid things with young women or girls who were minors. Redacted, and the records indicate that her concerning bringing this all the way to you, and her first, at that time, criminal chief, right, but sort of acting first assistant redacted, was because she was afraid of political pressure that might be brought to bear against the US Attorney's Office in this case. Do you have any recollection of that being a concern that was laid before you? I don't recall that briefing. I've reviewed this email and I can, you know, I take it. It would have been natural for me to say, should we approach the state attorney? Because we had lots of ongoing matters with the state attorney, and it seems that Redacted said no for fear it'll be leaked straight to Epstein, and I assumed I'd let it be at that point. And do you know what he meant by it being leaked to Epstein by the state, by Barry Krishna, the then state attorney? So based on the context, what I would assume is that if the state attorney is cutting this kind of deal, and it appears that things have already leaked, because, you know, there's clearly an article here with leaked, you know, so something is already leaked. You're referring to Exhibit 1. Exhibit 1. Other things would leak. Had you ever met Barry Krishna? Sure. What was your relationship with him? So there were multiple state attorneys within the district. It was a professional relationship. It was an elected position, correct? It was an elected position. And what was your assessment of his aggressiveness as a prosecutor and his capabilities? On the public, most of my assessment with him was on the public corruption front, where we have brought several cases, and I was a little disappointed that these were cases he could have brought that he chose not to bring. Right. So am I accurate in inferring from that you didn't regard him as a particularly hard-charging prosecutor? So with my state attorney, I hesitate to sort of paint broad brushstrokes. I don't think that's always fair, but my experience has been in the public corruption space. Yeah. And in that space, I did not think, whether it was him or whether it was his office, I can't speak, but I did not think they had done as much as they could have done. Is there any area in which you thought he and his office did pursue aggressively? So as I recall, we had emphasized gun crimes quite a bit, and really had a lot of success moving the ball in the gun crime space in Palm Beach. But let me just say, it's also very difficult to reconstruct timeframes. And so I hesitate, because I don't know if that was 2006 or 2007, but you asked in another area, and in this Exhibit 1, you ask whether it's appropriate to approach Barry Krishna and give him a heads up as to where the US Attorney's Office might go, presumably, right, with this case, correct. Why would you want to extend that deference to him? Why would it matter? A colleague in law enforcement. I thought it was important for the office to work with state attorneys as a general matter, and I found that the office worked best when it had good working relationships with state attorneys, and with, for that matter, the agency SACs and others, and right. But again,
Rather than my asserting, I'm asking redacted, and redacted was saying no, and I don't know what the ultimate outcome was, but I would guess that we just defer and let it be. Turning to Exhibit 2, this is an email that was forwarded to you by redacted. The original forwarded email is from redacted, copying redacted, and it essentially relates to a dust-up between redacted and redacted over chain of command and her workload, but in the first paragraph she specifies that, when I first heard about the Epstein investigation, I spoke with redacted about it. Redacted was not here. Redacted said that she would back me up on the case, but I knew what has happened to the state prosecution can happen to the federal prosecution if the US Attorney's Office isn't on board. So I spoke with redacted about the case, and he spoke with Alex, and they gave the green light. So that actually appears to be an initial contact with redacted that she's talking about prior to the briefing of you, so way early when the case first came in May of 2006. Do you recall being contacted or having a conversation with redacted about that case so early? Again, the early recollection. Whenever it might have taken place, was I made aware of the matter. It seemed a reasonable matter to pursue, and that's the level of detail that I recall. So if redacted said back in the day that she got from you all the green light, what did you understand her to be authorized to do? Authorized may be too strong a word, but so to pursue, to investigate, to pursue. Yeah, to someone. You know, I'm speculating here, but there's a case, and they want to know, should we spend our time on this? And the answer is, it seems reasonable. Sure. Okay. And do you recall making that explicit to her? I don't, and it wouldn't have been my practice to sort of make it explicit to, yeah, go spend your time, as opposed to, thank you for letting me know, that sounds reasonable. Alright. And whatever, details, it looks like based on Exhibit 1, there was subsequent follow-up between her and redacted, or with her and the management team, and they said, go back, work on A, B, and C. Do you know what redacted was talking about when she referred to something happening to a federal prosecution if the US attorney is not on board? Had there been a case in which you were not supportive of a particular prosecution that was being proposed? None that I recall, and I knew that what has happened to the state prosecution can happen to a federal prosecution if the US attorney is not on board. I don't recall any federal prosecution that I wasn't supportive of, at least in this context. What do you mean by this context? It was my way of narrowing an answer, so I didn't spend the time to go through every office and every division. For the most part, as I sit here, I'm sort of running through each office. I don't recall any, and if I could, based on this, on Exhibit 2, I'm not sure that she's referring to a specific case as opposed to concerns that the state prosecution started a point, with charges that required jail time and ended up somewhere else, and it may have been because management, alright, wasn't. But that's a current reading of, that's my recollection. That's my reading, not, alright. Based on the early description you got of the case, right, did you have any idea how many victims were involved? I did not. Did you know what the name of the case was? What the investigation's name was? Cases get names. So, I know that based on review of the correspondence, I may have known that then. I do not independently recall that. That being Operation Leap Year. Correct. Alright. And do you know where that comes from? Other than February 20th, I don't know. Well, the original allegations that came in involved 28 victims, and then subsequently redacted advised that she was uncovering more victims, so there was, over 30 victims. Well over 30. I did not know that. Alright. You did not, as you sit here today, you didn't know it. I don't recall knowing that. But is it reasonable that the number of victims would be one of the factors that you would have been informed of at that time? I don't know. It all depends how detailed that briefing was. Again, as a typical matter early on, this is what is being done. I would trust my officers and my management staff, right, to pursue it. It wouldn't be here are all the facts associated with this case, just heads up. There is a high-profile case involving a very wealthy man abusing young women. A state attorney is prosecuting, but there's dissatisfaction. I wanted to give you a heads up, both to inform me, but also so I'm aware in my interactions with other Palm Beach officials. Okay. Based on whatever information you got at the time, did you think that there was a federal interest to be served by pursuing a federal prosecution potentially? Yes. And what was that? So, the exploitation of young women. Girls. I want to be minors. Minor females. Alright. For a sort of a glossary convention. Right. that we are using is, and we can use in this interview, is girls. Right. For the victims who, at the time of the conduct, were minors, and women, for those who are not, even though the girls at a later time became age of fair. Majority. Fair. Okay, so here we're really talking about the girls. Okay, who were victims. Yeah. Okay. Girls, minor females. I just don't... Sometimes that term is viewed differently, and so, right. Yeah, so the exploitation of girls or minor females, and that certainly is an important federal interest. Well, and is the number and the breadth of the scheme, the scope of the activity, also a factor there? In other words, it wasn't one or two on one or two occasions. So there's several factors that probably go into what's the federal interest. The acts, the sordidness of the acts, the number, the likelihood or the importance of registration was important to my mind because that goes to further prevention, to putting the community on notice. And were you aware that the individual in this case, Epstein, also had homes in other districts, and that it was an interstate activity on his part? The interstate travel and so on? Mr. Heron, I'm sorry, we're still in the original intake time frame. Misredacted. Yes, Mr. Heron, here. The witness. Yeah, again, for the intake time, I can't speak to the details, because I don't remember what the extent of that intake briefing.
Ooh. Harry Potter ZR2QM. What did I just get in my recommended? I am live reading the entirety of the Epstein Files. All of it's being read live. Oh, 3.5 million, I think, files so far. And I'm on file, what is it? 9,274. So yeah, welcome. I'm reading the Epstein Files. Sit back and listen to my suffering. Speaking of suffering, my throat's dead. Oh, Jesus. By misredacted. But could I ask? Yes, a question. Was there a clear briefing as opposed to a heads up based on the record? Yes. That redacted came to Miami to conduct a briefing of you and, okay, redacted, in order to tell you about this case and get from you, okay, a green light. To proceed with it. I asked because I recall an email, and I don't know what the time would have been, where she's coming to Miami, and redacted says, why don't you stop by my office first? Right. And I would speculate that, why don't you stop by my office first is, why don't you give me a bunch of details, and then we will walk across to the US attorney, right, and fill him in. And so that would have been almost a two-tier discussion. And is that, I don't know if the timeline on that email is when you say briefing. Well, we are asking, what it would, be. I'm speaking just based on review of the record, not based on recollection here. Alright. So, to be clear, you have no recollection of any specific briefing in 2006. I accept that I was made aware of the matter. Okay. Sounds like a fun time, hell yeah. I can't say how or in what context or to what degree of detail. Or by whom? I knew the matter. It's easier to recollect, at least for me, what I knew as opposed to who told me what. Alright. At this point, at any point, did you have any reservation about investigating and potentially prosecuting Jeffrey Epstein? A reservation stemming from his wealth and reported standing in the community at all, and influence? No. And we have prosecuted lots of influential folks in the office. So, while he had wealth, it's not unusual. UBS was in the office at the time. I mentioned several high-profile Palm Beach public corruption cases. So there was no concern about possible negative blowback in the press, or the community, or even at Main Justice, if you went after someone like Jeffrey Epstein. There was no concern stemming from his wealth or his status. What would it have stemmed from? At some point, I think there was concerns regarding the law, and we'll probably get into that. I alluded to that earlier in the overview. I don't know if that would have been developed this early on, but that's not a function of his wealth. That's a function of the fact pattern. Right, okay. So as you mentioned petite policy concerns, could you tell us what your position was on the policy as it applied in this case, as you understood it from in the beginning? So the policy, on its face, doesn't specifically apply.
Based on Exhibit 1, I'm now inferring, not recalling, it looks like either Redacted on her own or Redacted asked for a... or Mr. Redacted asked for a petite policy waiver memo to be prepared, in part on the assumption that the state prosecution may or may not have gone for it. I don't know, but I do recall that early on this was unusual because he had been arrested or arraigned. It was going forward on the part of the state, and so here is the big bad federal government stepping on a sovereign, state, saying you're not doing enough, and to my mind, when, the whole idea of the petite policy is to recognize that the estate has, is an independent entity, and that we should presume that what they're doing is correct, even if we don't like the outcome, except in the most unusual circumstances. And what kinds of... well, no. Well, so the petite policy exists because there's a recognition that there are cases that are appropriately pursued. I mean, you are the head of the Civil Rights Division, after all. Correct. Which is why I say except in the most appropriate of circumstances. Right. But let me add that based on this, I was comfortable, saying, let's go forward because the lack of jail time, to use petite policy language, a plea that did not include jail time or registration would seem like a manifest injustice. Alright. So, did you have any doubt that you'd get a waiver if you applied for one? I'm not... So I'm now speculating. I don't recall, but I'm not sure I would have said. Is there a doubt that I get a waiver as opposed to... is this something I feel comfortable doing, or not? And this being the prosecution, or this being the... applying for a waiver? Applying for a waiver. And so, either main justice gives it or doesn't give it. That doesn't mean you don't apply for it if you think it's the right thing to do. So, for example, in the UBS case, which was one of our big tax, prosecutions, we asked for a Bank of Nova Scotia. Authorization to the Bank of Nova Scotia, subpoena. Subpoena, sorry. And I didn't think main justice would, I pushed really hard, and I got into the weeds in that case for that purpose, but I still thought, let's go for it, and we did. And main justice didn't give into it, and that's okay. That's how it works. Okay, so they denied that request. They denied that request, and I say that as an example of... as a typical matter. I don't think what's main justice going to say, as opposed to how should we approach this matter. I don't understand about what you mean by how should we approach this matter. So honestly, how do I explain this? So I think there's a difference in saying, let me predict how main justice will come out and follow that prediction, versus, folks, what do you all think? Sorry, let me redo that. Versus, folks, what do you all think? Okay, if you're comfortable with this, let's write it up, and let's see what main justice does. One is trying to predict what folks in this building are going to think. Another one is trying to predict, another one is saying, what do we do in Miami, think, and then let main justice figure it out. And which is the approach you typically took? And my point is, the approach that I typically took is, what do we think, and let main justice give it a thumbs up or a thumbs down. Alright, and in this case, how did you do that? Let me redo that. Alright, and in this case, did you do that with regard to the petite policy? So in this case, we didn't get that far in, that we didn't have to submit to DOJ. But we were approaching it not based on what main justice was going to think, but what do we feel is the right outcome in this office. So, as I understand, the bottom line is that you didn't... As I hear you, I believe you're saying that you didn't stand down or in any way cease or limit pursuing this case on petite policy grounds. You pursued it as you would. So we went forward with the matter, although there were petite policy concerns in the background. So you're setting this up as a binary. Was it a fact? As a binary, you did not limit yourself on petite policy grounds, and I'm pushing back a little bit because I don't think it's part or it's not. As opposed to when you look at a case, there are all sorts of factors, and it is a factor in how you think of a matter going forward. By misredacted. If you had those petite policy concerns, you or members of your staff, I would say a combination of me and my management staff. By misredacted. Who? I can't recreate, but who are you dealing with on this case? Primarily, it would be my first assistant and criminal chief, as I typically... So, there is, to sort of put it in main justice terms, a line attorney has a deputy section chief, and a section chief and a DAG and an AAG, and the AAG usually deals with the section chief or the DAG. And so I was dealing with my first assistant and my crim chief. Right. And they were there in Miami, and they were there in Miami. And by the way, redacted, first line supervisor was redacted? Correct. Do you know why she was not actively participating in this chain of command? I noticed that in the correspondence, and I couldn't speak to that. Alright. But it goes to the point that if you look at she reported to redacted, who reported to redacted, who reported to redacted, who reported to redacted. And so, as a typical matter, I try to empower my first assistant, and my criminal chief, and my office heads, and work through them, not bypass them. In this particular case, with regard either to the petite policy, right, or any other aspect, was there anyone other than that group of 5, if you will, in that chain, correct, from you down to redacted, through redacted, right, and redacted that you were dealing with? I can't recall. I can say as a general matter, it would not be unusual for me to walk down the hill and talk to someone that I trust and say, hey, I've got this fact pattern. What do you think? Do you recall ever doing that in connection with this case? I don't recall the specific briefings or who I talked to. I'm just saying as a general matter that there are folks on the 8th floor that were in management that I would often just walk down the hall and... But do you recall doing that? I don't. In this case, I don't recall. Okay, so we shared with you in Exhibit 3 a pretty lively exchange between redacted and redacted. We have no reason to believe you saw this before, but it makes some representations about you, and that's why we brought it to your attention. Okay, do you recall this email exchange? I don't recall the email exchange. But I didn't see it then. Do you recall having read it before today? I recall reviewing it, yes. Alright, okay. So starting from the end, redacted, using redacted BlackBerry, which is a little confusing to begin with, notifies redacted that of a particular conversation he had with one of the defense attorneys. At this point, what I want to do is draw your attention to the comment and his response, and we're looking at page 3. Page 3. So in the 3rd paragraph, yeah. It was made clear to you by the U.S. Attorney and the First Assistant from the time when you were first authorized to investigate Mr. Epstein that the office had concerns about taking the case because of petite policy and a number of legal issues. And then later he says that you were never given authorization by anyone to seek an indictment in this case. And, close quote, and then on the first page, redacted presents her version of that original contact with you, meeting with you, at the bottom of the page. Halfway through the last paragraph she says, my recollection of the original meeting with Alex and redacted is quite different than your summary. In that meeting I summarized the case and the State Attorney's Office handling of it. I acknowledged that we needed to do work to collect the evidence establishing a federal nexus, and I noted the time and I noted the time and money that would be required for an investigation. I said I was willing to invest time and the FBI was willing to invest the money, but I didn't want to get to the end, and then have the officers be intimidated by their high-powered lawyers. I was assured that would not happen. Can you tell us which version of that initial... Which version... Right, is correct. So again, I don't recall that initial briefing, so I can't tell you which version is correct. I would also say that it's possible neither version is correct, and that there's a little bit of truth. Now, I'm just speculating. Alright. That there's a little bit of truth in either one, because it's certainly possible to say. I hear you. Righteous case, go forward and investigate, work on the federal nexus, which is what Exhibit 3 is saying. Go work in the federal nexus and find evidence for the federal nexus. But we have concerns about petite policy and legal matters, so there's a lot of work to be done. So what kind of a direction does that amount to the line Orsa? What's her job then? So the job would then be to go back and investigate and develop facts and report back. And if she developed enough facts and supportive law to present proposed prosecution... Right, okay. And so a lot of times in this, she said, there's a little bit of truth to both sides of the discussion. I'm just saying as a general matter, I wouldn't... Your questions are sometimes either or, and sometimes right. It can be a combination of both. Alright, but in fact you don't recall. But I'm speculating. Alright, is there anything in either of those that two versions that you say didn't happen, couldn't happen? I can't because I don't recall it. I can't... Okay, speak to that. I would speculate that there's probably a little bit of truth on both sides that, and if you read it closely, you'll see that redacted acknowledges the need to work in a federal nexus. So that goes to, where redacted or Mr. Redacted... I'm sorry, I'm using first names. It's alright. So I'm going to just start. This is an informal interview. I'm going to just start using first names. I don't mean that disrespectfully, where, redacted says, because of petite policy and legal issues, and redacted is acknowledging the legal issues because she's saying needed work to do to collect evidence establishing the federal nexus. Alright, so, yeah. So they're not as inconsistent as presented. Alright, arguably. Back in 2006, in this exhibit number 1, redacted tells you in his email that the indictment target date is August 25th, 2006. In other words, very shortly, thereafter, within a month or so. Do you know why the line author, redacted, was keen on getting the federal case against Epstein brought on a quick basis? So I can't speak to that, and can I ask, based on your record, was that the state indictment target date, or was that Epstein had already been indicted and arraigned on the indictment. So that's the federal. So that's talking about a federal indictment. All right. The point, correct, is that early on, the investigative teams, the FBI, and redacted were hot to trot to get this case moving from a federal standpoint. That may well have been quite unrealistic given, correct, all of the issues that we've been discussing. But the question is, do you know why there was some urgency? I haven't the slightest idea. When was it? When was it initially brought to the office? It was brought to the office in May of, 2006. That will be a really, really fast timeline. Right. So the question is, aspirational though it may have been, there was a hope, to get it done quickly? Right. So the question is, can you think of factors that would have led a prosecutor to want to pursue, this quickly? I don't recall. I can speculate that redacted was very hard-charging and wanted to do a lot, and was that your experience of her? So based on this, I see, so Exhibit 2 is, excuse me, but just from your memory, is that your recollection of how redacted operated? Hard-charging? Yeah, I'd say. So a lot of really good prosecutors are hard-charging. That's alright. That's part of the job description. Okay, and so yes. So I'm just going to close a few programs because I think my Streamlabs is running a little bit slow. Right, there we go. All right. This was, a priority? I've heard that discussed recently in the media. I don't recollect that part of a discussion back in 2006. Alright, okay. Do you recall that redacted? And this is just, do you recall? That she periodically would give you in that early period of 2006 updates, written updates. I don't... Did you think that it was appropriate for a line author to be shooting emails updating on a case that was under investigation directly to you and your first assistant? It was unusual, and so did I think of Look, I can't reconstruct what I would have thought. But, you're asking not just what did I know, but what would I have thought 12 years ago? Just checking. Stream, I'm talking about, freezes on my end. It's it keeps the chat, it keeps the image, but, my mini feeds, my audio settings, the amount of people watching the stream, I can't necessarily see those settings. They sort of vanish, and I think that means it's, it's taxing on the system. You might be able to hear a little chime in the background. That's my tumble dryer. I might deal with that in a bit. I might make myself a cup of tea first. Yeah, this is empty. Okay. But I can say that based on general practice, it would have been unusual. And my best guess as to how I would have reacted would have been, hey, redacted, this is unusual. Is the chain being fully informed? Our feather's been, ruffled. Figure it out because, you asked me early on to characterize redacted's qualities. I think one of the things that I said was he was very good at smoothing things over. And sort of the interaction, because he was respected. And so I might say that's kind of unusual. Go figure it out. But you wouldn't necessarily jump at that chain yourself and be... in direct communication. I tended not to... Okay, do that. By redacted. Would she have sent this to you? something unusual if she thought that this was a case that you wanted to be involved in? Even in those, I think this is a different person questioning, but I'll keep the same format just for ease of doing it. Would she have sent this to you, something unusual, if she thought that this was a case that you wanted to be involved in? Even in those, I try to be, as a general matter, fairly sensitive to the chain, because I had found that if you start jumping the chain too much, even if you become informed, managers feel, out of the loop, and that's not conducive to sort of allowing them to do their job of supervising. It's a big enough office. You have to empower your folks to do their jobs. So the concern on your part would not be that she was communicating directly to you, but that as long as all of the chain of command was informed as well. Yeah, I mean, if you're redacted, or don't want to talk to the line attorney before the line attorney talks to your boss. And so it's not just informed, but it's respecting your supervisor. And it's difficult balance, because often really good authors are also the ones that, just want to get things done. By Ms. Redacted. Did you have any reason to believe during this investigative phase that Redacted was not pursuing this investigation adequately, appropriately, and fully? No, I did not. Did you? Not to my recollection. Did you feel that she did not have appropriate oversight? Not to my recollection. Okay. Did you feel that she had any resource problem? That is, did she have, as far as you know, sufficient resources available to pursue her investigation? To my recollection, yes. I noted her early. I noted more recently the email where, that was shared with me by Redacted about resource concerns, and I would just note that I would allow the management chain to figure that out. Alright. Did you at any point consider, based on what you then knew, expanding the scope of the investigation? Did you ever suggest or propose that instead of simply looking at Epstein's conduct in West Palm Beach via a vis-a-vis these girls, that the federal authorities could use their resources to look at other aspects of Epstein's activities? So I think it's important to take a step back. And I was aware of any number of cases going on in the office, and based on what that stage of case was at, I would get more involved for a time. It wasn't my practice to direct authors in how they should investigate, or what the scope of a case investigation should be. The Miami office, before I got there and after I left, had a reputation for knowing their stuff. It's a large office, it's got good people. I would assume that authors and their management would follow their natural leads. Alright. Were you aware that during this period, and by this period, I'm talking about the investigative period from the time that the case came in mid-2006, right, up until May 1st when Redacted put forth her pros memo, right, and proposed indictment. During that sort of 10-month period, or almost a year, were you aware that defense counsel for Epstein were reaching out to Redacted and to Redacted to pitch their view of how the case... Right, should proceed. So I don't have a specific recollection of who reached out at what time. I would assume as a general matter that defense counsel were clearly involved before the case came to the office. And so I would assume that defense counsel would remain involved while the office was investigating. I say that not based on independent recollection, but right. Why would they stop being involved? And is it, in your experience as a US attorney, was it common or uncommon for defense counsel to approach the line prosecutor and supervise to make whatever pitch they want with respect to a prosecution? Fairly common. Alright. And was it also common for those approaches to be entertained? In other words, for the line author and supervisor, right, to meet with defense counsel? As a general matter, yeah. And did you view that as appropriate? As a general matter, it was typical. It happened before I got there and is probably happening now. And you view it as an appropriate part of the process, do you? I think authors need to have direction to meet with defense counsel, or discretion to meet with defense counsel, sorry. And defense counsel certainly should be able to present perspectives. There is an outlook. This is Exhibit 4, and this is something, okay, it's really sort of a point of information here. This is an outlook that shows you and Redacted had a scheduled meeting with Roy Black. Roy Black, a prominent, local criminal defense attorney at the time in the Miami area. This was a meeting scheduled in your office for the 23rd of February of 2007. Do you have any... He at the time, it was one of Epstein's attorneys. Do you have any idea whether this meeting related to Epstein or some other case? I don't. I noticed that, and I don't know whether it was this or another matter. But you have not particular recollection of meeting with him on the Epstein matter? I don't. At this time? Okay. So I want to, and let me note, I think most of the correspondence was from other attorneys and not him. And so, yeah. Alright. Are you okay? Do you want to take a short break, or... Yeah. What time is it? Oh, 11 o'clock. 5 minutes? Yeah, 5 minutes. Yeah, let's take a 5-minute break. Off the record. Off the record. By Miss Redacted. Ooh, I'm tempted to take a break as well. But no, I'm going to power through. How's everyone holding up? We've got some very interesting stuff here. I'm going to look to clip all of this, and I'll probably wait to see what's ahead in dataset 7, but there's a reason why that this is essentially its own dataset. And this is the majority of dataset 7 as well. Just this interviewing this person here. So from what my understanding is, he was the head honcho at the time, but there's a massive chain of command. So he was the guy right at the very top. He did have some say in this, at least if what he's saying is correct. But there's a little bit of Chinese whispers, and there's a little bit of a laissez-faire management style. Essentially, he's not a micromanager, which, okay, that I can respect. And he's letting his subordinates, carry out their duties. But the big question is, with this, who is responsible for not pursuing Epstein to the degree they should have in Florida, during the Florida investigation? Because Epstein only ended up with 2 years in prison, which got knocked down to 1.5 years. And I think, from my understanding of that whole thing, although it may change here, from my understanding, that is because he cut a deal. Some kind of deal. Like a plea deal. So, I don't know. Why did that happen? Was it, lack of resources or something else? But it seems like here, it's just this guy wanted to get along with the, state attorney, local attorney, that kind of thing as well. And I think this bureaucracy did kind of slow things down a little bit. But I don't... This is not necessarily to say that this guy is, innocent. I mean, he's... At the end of the day, he captained the ship. And he probably should have said some things in there. But yeah. The police had nothing to do with it. The police in Florida did a damn good job. I will say that. The police in Florida did a damn good job. But they did note that the attorney's office and all of that, they were slacking a little bit. But I think, is Barry Krishna, I think the name was? That was the guy that they noted as not prosecuting harshly. And that, from what I can tell so far, that might be the point of the weak link in the chain. But I don't know. We haven't even gotten through 25% of this yet. I think I will definitely take a break when we finish this file, which is, all of these files are like 100 pages with the exception of this one. This goes from page 300 all the way down to 412. So yeah, it's 25% sort of. All of these, this is 100 pages, this is 100 pages, this is 100 pages. These files are very, very dense. Densely packed. Barry Krishna does sound very familiar. I think he might... I don't know. I think some action might be taken against him. Yeah, I think Barry Krishna might be the prosecutor. I did also... I mean, the name has come up before. I don't know if he's obviously not one of Epstein's attorneys if he's, part of the whole prosecution stuff. But he has definitely been named before. Excuse me. Alright, I'll carry on here. Alright, back on the record at 11:12, having broken at 11. Mr. Acosta, we're going to move on to that time frame I mentioned a moment ago. May of 2007, when Redacted submitted her prosecution memo of more than 80 pages and her proposed indictment. Her initial proposed indictment, which was more than 50 pages. She submitted that by transmittal memo to her entire chain. Redacted, 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 and you. Was that a typical way for an indictment and proposed prosecution? The memo to come? To my recollection, it was not, and I don't recall that happening in other cases. I'm hesitating just because I'm trying to think through if there's... I don't have any recollection of it happening in another case. Why do you think it happened in this case? And who caused it to happen? I don't know, and I don't know. Alright. So, before you saw it, I don't know if you even knew about it. By reference to Exhibit 6, you learned essentially from Redacted that the FBI was planning to do a press conference 2 weeks after that. And Redacted, this office had not approved the indictment. Therefore, please do not commit us to anything at this time. Were you... And eventually that email chain, right, gets to you, apparently by blind carbon, because there's no indication you actually get it. Right. But you advise Alicia Vale, who I think was your press person, correct, that Redacted hasn't even finished her recommendation to Redacted, i.e., we are a long way off. So, did you have any idea why the FBI was planning a press conference on Epstein? I don't know if I did. I don't recall if I did. Was it? How typical was it for the FBI to plan a press conference on a case that was being indicated at the time of an indictment or arrest without coordinating that with you and your office? Under Redacted, highly atypical. He was the SAC at the time. He was the SAC. I know he was the SAC at the time as of September, and I'm almost certain he was the SAC at the time. Alright. And when you said that we are a long way off, and Redacted hasn't even finished her recommendation to Redacted, do you know whether you had any idea that she had actually submitted her pros memo, and that she had made a recommendation to Redacted? I can't recollect. Okay, but I'll take my words as reflective of, if I say she hasn't finished her recommendation, then I assume she hasn't finished her recommendation, but I don't recall, does that mean that level of detail? As you look at your own words, does that suggest to you that you were unaware, as of that moment, that she'd actually submitted her pros memo? That suggests that I would not have been aware that she submitted it. Because it sounds like I'm saying she hasn't even submitted her memo to Redacted. So, alright, we're a long way off. Alright, but again, this is based on practice, not recollection. Alright. And when you said we are a long way off, did that reflect, if you recall, an assessment of the length of time to get to a memo? A recommendation and an assessment of that, or your expectation that even when you saw a pros memo and an indictment, it would be a long process before it was approved? So, I would assume, and again, this is just based on speculating from the way that I write, that I'm thinking she hasn't submitted a recommendation to Redacted. Redacted needs to review it. He may, he'd probably want to talk to Redacted. It needs to be scrubbed. This ain't happening next week. Alright, but do you have any reason to believe that whatever that process is that you are describing would be any different in any particular measure in this case from the ordinary complex case? So in my language, I would take that it's the same process, but that there is a process, and the process hasn't yet been followed. Alright, okay. So it would be the typical process in a typical complex case. Alright, and is it fair to characterize this as a relatively complex case, given the legal issues? I think it is, yes. Okay. In Exhibit 8, you actually got in Exhibit 7, you see that in the bottom part of that you received a copy of the pros memo on the second page of that exhibit at the top. Right. Redacted is forwarding to you the pros memo. Alright. In Exhibit 8, you see that Redacted is forwarding or sending to that chain, excluding Redacted, that is, Redacted, and you, additional items in Operation Leap Year, and that's a summary of the indictment, and evidence regarding the individual victims. Okay? So, as of May 11th, you had before you the pros memo, the proposed indictment, and this substantial amount of additional, information. Did you read the pros memo? Right. So I don't recall. And I know you're going to say, why don't I? But this was a long time ago. I don't recall if I read it, or if I went back to the office and sat down with Redacted and went over it. I can't recall from this far. I can say that it looks, based on this, that I was at the US Attorney's Conference. The idea of printing this out on a hotel printer, I can't believe I would have printed this out on a hotel printer. Let alone read it on an airplane, correct? Let alone read it on an airplane. That just wouldn't, have been my practice. But arriving back, to your office. Was it your practice to take voluminous documents like this and go through them yourself, or did you rely on your senior staff? I would typically rely on senior staff. They're the experienced ones that have seen these matters before. They would go through it. We sit down, we talk about the issues. We might have it in front of us, almost like you've got all those, binders there. But you're calling my attention to particular issues, and we sort of talk it through. And do you recall doing that in this case? I recall having discussions with senior staff about this case. Who? Certainly redacted and redacted at various points, and I can't say that I did that in May versus April versus June. I can't give you, timelines. Well, we're talking now about May, because you got the actual, process. It would have been my practice based on this to go back and discuss it, and so based on my practice, I would have gone back and lightly discussed it. I doubt I would have printed this out at whatever hotel I was at. But even when you got back to the office, would you have had somebody print it out, so you would have had it available? I may have had someone print it out, so it's available. I may have focused on particular parts of it. What kind of issues would you have focused on? In other words, some might go straight to the facts. Some might be interested in the legal theories. What was your approach? So I think that depended on the case. Okay. Here you had legal questions, and you also had witness issues, and I would think those would have been the two primary areas. Would you have gone through the indictment and the pros memo and all of those other materials, or just relied on your experience seeing your people redacted and redacted? As a general practice, probably some combination. As a general recollection, the concerns in this case weren't about the sordid details of what happened, because we believed he did what he did. The concerns were about some of the legal issues around it, and some of the issues in terms of the testimony. Of the victims? Of the victims. Alright, on page, and I say that because that would have been what I would naturally focus on, as opposed to reading these sort of details, because I think everyone believed the victims. Alright, Exhibit 9 is an email that you are not on, but that notes that redacted is advising redacted that you, redacted, has your memo and Lefcourt's letter. Gerald Lefcourt was, a New York attorney who was one of the members of the Epstein defense team. Did you know him? I did not. Did you ever encounter him, as far as you recall? I did not. Alright. He had, according to the documents we have, made 2 substantial submissions to redacted and redacted in, February of that year in an effort to dissuade them from pursuing a prosecution, and we have every reason to believe, and no reason not to believe, that that's what is being referred to. Do you recall reviewing substantial submissions from defense counsel at this time, attacking in very granular detail, the credibility of the witnesses, and so on? I don't recall reviewing those. Again, I recall discussions with my senior team about issues that included the credibility, and I'm not sure if it's... credibility is the right word, but how the victims would do on the stands. Okay, and who do you recall talking to you about that? So, some combination of redacted and redacted would have been the likely... I recall the discussion. I don't recall whether it was redacted or whether it was redacted or redacted, but the logical inference would have been it would have been some combination of redacted and redacted. Redacted has told us that during this period he was not actively involved in this case. But that redacted was. Would that be consistent with your memory, or would that... Sure, they were a team. They became more or less involved based on needs. And was there any particular... If redacted was working with you directly on reporting, on his assessment of this case, was there any reason for redacted to be involved? I might bounce ideas of him. He was right across, so he worked closely, but redacted was the criminal chief, and if he was in the weeds, redacted, I would speculate was sort of, much like me, defer to his judgment, because they've known each other and they've worked together, and they had a good working relationship. And do we understand correctly that as first assistant, redacted had a brief that really encompassed the entire office? He did. Alright. So he supervised the civil, the criminal, the appellate, and the forfeiture. Alright. There is here in this email that you did not see back in the day, Exhibit 9, a pushback from Redacted regarding the rush that Redacted is in to pursue this case. And he says, this is obviously a very significant case, and Alex wants to take his time making sure he is comfortable before proceeding. Do you Can you tell us what the basis would be for, or was for that assertion, by redacted? So, I can't tell you from recollection what the basis is. I can speculate that the material is being transmitted Friday morning. Oh, I guess it was. Yeah, so, the 11th. Yeah, Friday. So, Friday morning. It hasn't been reviewed by anyone in the management chain, much less approved and edited, and redacted that Monday as saying, why don't I have a decision? And so, absent truly extenuating circumstances, typically you'd it'd go through the management chain up to the US attorney, and so he's pushing back, saying, hey, it's been a day, or it's been a weekend, I'm just reading between the lines here. Who had authority to sign off on the Epstein prosecution? To, say, indict? So, as a delegated matter, redacted has signature authority. As did redacted, and obviously I did. As a practice matter, this is something that would have gone through the chain, and that we would have then discussed. But why up at your level? Is it because it is, as redacted says, obviously a very significant case? So, at my level, not only because of the facts, because it's not about the facts, but I do think that there are legal issues that implicated policy that we were thinking through. And what were the legal issues, and what were the policy issues? So the legal issues, and also factual issues in terms of the witnesses. So the legal issues. And there's an email from redacted based on the contemporaneous record that alludes to some of this. In my experience as the Civil Rights Division, trafficking cases involved, I can describe some horrific cases of girls being held against their will, You had child pornography matters with young women, sometimes incredibly young, that the office prosecuted. As the trafficking laws were being developed, there was a lot of discussion about what's the difference between trafficking and solicitation, and that discussion took place as the trafficking laws were being developed, and so this implicated the what is local and what is federal. Alright, so in the first category, you're talking about the individual charges that were being proposed, which included both trafficking and coercion and enticement. Correct. Alright, and in the latter, you felt that, to what extent did the victim witness, kind of credibility issues implicate policy? So I think I said policy and victim in that. Alright. In that there was certainly discussion between me and my management about concerns as to how these victims would sort of stand up in court. So, what would make you comfortable before proceeding? What at that point would have made you comfortable about proceeding? So I think that at this point, I don't think it's what would or would not have made me comfortable, and I'm speculating here. I think it came in on Friday. Let's talk this through. But you've just identified for us issues that in your mind we would have had to be resolved, wanted to talk through. Alright, okay, at that point, did you, to your recollection, have any doubt that some form of indictment or charging instrument against Epstein was likely to become viable? So it was a case that I thought it very important that we do something. How that something played out, I think, had all along been a matter of discussion. As something other than what the US Attorney's Office does, which is prosecute? Well, no. I mean, what the US Attorney's Office does is ensure that justice is served. Right. And in partnership with state attorneys, and sometimes that means state attorneys take the lead. Sometimes it means the US Attorney's Office takes the lead, and a lot of times we actually had, we would share stuff, because sometimes it made sense for one part of the other to take the lead. So, writ large, I thought throughout it was very important that something happen. There were these concerns all along. I can speculate that this is just a reflection of those continuing concerns. As expressed by you to redacted in the ordinary course, as developed as a group throughout this, so, if we go back to, what was the exhibit? June of 2006. So, Exhibit 3, redacted says, in that meeting I summarized the case and the State Attorney's Office handling it. I acknowledged that we needed to do work to collect evidence establishing a federal nexus, and I noted the time and money that would be required for an investigation. And so, as far back as that initial meeting, there was the discussion about the federal nexus, and is this a state or a federal, case? Alright. Exhibit 7 is an early email from redacted to you. Early, meaning it precedes the one, correct, we just looked at. and early in that his right is your right. Receiving the pros memo, and you ask him, have you read the memo? And curious why you ask redacted rather than redacted? I don't recall. I can speculate, and I have two thoughts that I'll speculate. One is redacted, her direct supervisor. And I might be thinking, second line supervisor. Her second line supervisor. So why is redacted sending me this? Redacted, have you read this? Did you jump the chain? Secondly, I may have wanted to have multiple opinions on this. It's most likely that I had talked to Redacted already, because Redacted and I talk more often, and I'm asking another person in the management chain, hey, what do you think? Let's have multiple opinions on the table here. Well, this is the first time other than Redacted that we see you getting a recommendation. Right. When Redacted says he thinks that you should charge him, you, the office, should charge Epstein. He has issues with the charging strategy proposed by Redacted, but one, he says, we all need to get on the same page as to whether the statutes covered the conduct, and whether the conduct is the type we should charge. I think the answer to both is yes, although there is some risk on some of the statutes. He proposes that the office start with a complaint, which is not unusual, is it? It happens, yes. Alright. Which allows the defendant to be arrested and ideally detained, and then the defendant is then highly motivated or incentivized, to work a pre-indictment resolution. That's what Redacted is proposing. He also knows that it's important to, in his view, to cap him with conspiracy counts to make a plea attractive. And the court could give us a hard time with that if we had to dismiss indicted counts. Right. Okay, the proposed indictment included one conspiracy. A conspiracy that has a 5-year cap. Statutory maximum. And this notion is that Epstein be charged with a 5-year conspiracy count and take it from there. Do you know what he was referring to when he noted that a court could give you a hard time in dismissing indicated counts in this case? So as a typical matter, once there's an indictment, a pre-indictment, well, by definition, a pre-indictment resolution comes off the table, but in cases of this nature, the resolutions tend to happen before indictment, because once the indictment is done, at least in South Florida, dismissal of charges. For example, if Redacted is saying, let's think about a 371 with a 5-year cap, a Rule 11, that's something that South Florida judges. They tend not to, dismissing a number of counts and then doing a Rule 11 is not something that judges tend to do. Alright, two pieces to that. One is, the issue of dismissing substantive counts. Was that a particular concern in this case because of the nature of the conduct represented in the substantive counts? So your question, you asked a general question and then now you're moving to a specific. As a general matter, not just in this case but in other cases, it was rare that the office in cases like this, after a full charge was done, that the substantive counts were dismissed. So, for example, in the public corruption cases that I referenced earlier out of Palm Beach, those were all negotiated pre-indictment and agreed to, and then by the time the case was indicted, it was all sort of set on autopilot. Sorry, I'm stumbling a lot with these legal terms. So typically, in my experience, a disposition like that results in a criminal information, not an indictment. Correct. And are you saying that you would go ahead and indict then? No. What I'm saying is that it was all negotiated in advance, and then there was an information. Oh, okay. And the information would go forward, not an indictment. All right. And so that is how a number of high-profile cases typically proceeded, as opposed to indict and dismiss. And that is the experience of the Southern District of Florida in general. It was in particularly the Palm Beach office with other high-profile cases that were there at the time. Do you recall any case in which a judge in an indicted case refused to dismiss counts when the government, in an indictment under those circumstances? I don't recall specific cases, but I can say that typically in the higher profile cases, you'd negotiated with opposing counsel, presenting information. The information would have agreed to an agreed guideline, and it would proceed in that way. Understood. But in this case, I'm focusing on the assertion by Redacted that the court could give us a hard time, and that's a little different from, exercising discretion to negotiate and proceed by information. So is there any charge that was particularly concerning with regards to an unwillingness to... I dismiss? I don't... So, first, this is 12 years ago, and I don't recall any specific judge, but I can say that was not the practices of the office, or practice of the office. The practice of the office was to proceed by information rather than indictment with dismissal, because you can lay out more what you've negotiated. I think later there's a letter from Redacted that sort of presents the same perspective. Alright, in Ms. Redacted. One moment. Ms. Redacted. Go ahead. The witness. Yeah? By Ms. Redacted. You said in cases of this nature, the resolution happens before indicting. What is this cases of this nature? Higher profile cases. So, not necessarily sex offense cases. Not necessarily sex offense. No. Higher profile cases where... And this was a higher profile case because this was so I would say it's a combination of all of the above, and to my mind, one of the parts of this case is the legal theories were, if not novel, they were novel within the Southern District of Florida. At least some of the legal theories, and I will probably get into that. Did this well make it a high-profile case? Well, it was clearly in the paper, and so that made it a high-profile case. I don't think it was as well. I think it was all of the above. This was a matter that the state attorney had been ready to charge, that the federal government is now jumping into and saying, by its presence, that the state did not do enough. That in and of itself makes it a very high-profile case. I can't remember any other instance, certainly during my time, when we jumped in and said, the state dropped charges, and so we are going to do more. By Ms. Redacted. As opposed to, or as distinguished from what you described a few moments ago, a situation in which the federal authorities and the state authorities kind of work together to sort out what will be charged, where, and do it cooperatively. And that was more cooperative, and I do recollect that, and I think the record bears this out, that this was not a particularly cooperative relationship between us and the state attorney. Yes, we will get to that. Will you... If I could return, I think your question, the way you posed your question, you said a recommendation from Redacted, and let me push back a little bit on that. Saying, what are your thoughts? Have you read it? What are your thoughts? And he says, yes, we can talk next week. My current thoughts are, it's very different than we sat down, we discussed this, this is now informed position, or this is my now informed position. Understood, and I should have been clearer. I was referring to his recommendation that if you were going to proceed, you should start with a, complaint, just to be clear. And I'm just saying, okay, initial thoughts are, yeah. Alright, so were you aware that Redacted bootlegged a copy of the PROS memo to Redacted at Xios? I was not. He did at that time. Okay. And did you know Redacted? A little bit. I certainly knew of him. Had you encountered him when he was the chief of the Child Exploitation and Obscenities section? Right. In the criminal division here, correct? Had you encountered him while you were in this building also? Most likely. I knew of him enough that the correspondence shows, and I recall asking to involve him pretty early on. So it does read as if you are acquainted with him. Yeah, alright. And did his opinion, his views as chief of Xios and as Redacted, who had been an Orsa, right, in Miami. Did his views have influence on your thinking about this case? I don't think at this time I was aware that Redacted had been consulted. Alright. And in July, just so you know, and this is not something you saw, he provided a fairly strong statement by email to Redacted, in which he advises that he reviewed the PROS memo closely. It's terrific. He says Redacted did a terrific job, and he says, we agree with her legal analysis. Her charging decisions are legally sound. And then Redacted goes through the different statutes and concludes that they are all properly charged, and that although there are some issues legally that in his view we should we should prevail. Our position should prevail. And that he also reviewed the arguments contained in the letters from defense counsel, and he found none of their arguments persuasive. So, at least as of July 18th, you're right. 3 levels of supervisors down were on notice that CEOs was on board and wanted to, right, see the case move forward. But is it? Am I correct in understanding that at that time you were unaware of that? I do not recall being aware of that. Alright, okay. If you have been aware of it, if they had sent this, yeah, pretty... I don't want to overstate it, but it is a pretty strong endorsement of the proposed prosecution. Would you have been influenced by that? Sure, I would have. I mean, I respected Redacted and clearly wanted him to be part of the team, and later invited him down. And so, yes. Okay, alright. Do you know why they wouldn't have shared? Your people wouldn't have shared this with you? I don't know. Alright. So, based on the briefings that you got in this time period, when there was an effort to try to figure out, right, what you were going to do, were there any issues of concern of fact or evidence, or the charges that were left unaddressed? In other words, if there were issues about victim credibility, were steps being taken to address those? Unaddressed is it is a very binary, and it's not about addressed versus unaddressed. And so let me sort of come at it, if I can try to get... There were concerns around some legal issues. There were concerns about how the victims would do when put on the stand. Right. As a general matter, we thought there was enough if we had to go forward, we could, as an ethical matter, go forward. That doesn't mean that there was not value in a pre-indictment resolution. And so here you have Redacted, based on this Exhibit 7, saying, we need to get on the same page as to what to charge, pre-indictment resolution, capping with conspiracy count to make up the attractive. So a 5-year cap, something less than 5 years, you have Redacted in her affidavit that was submitted to the court saying she favoured a pre-indictment resolution. And so it's not a, have you addressed everything, yes or no, as opposed to putting all of this, alright, how do we move forward? Right, but there is a binary point here, and that is, you either indict or you don't indict. Or indict. I don't know how you're meant to say it. It's legal jargon. You either present an indictment to the grand jury or you don't, right? That's a decision, right? So I would actually push back in that in many cases. It's not quite that binary. In many cases, you sit down with opposing counsel and say, look, we can go to a grand jury and we can present this indictment and indict, or we can resolve this now. If we resolve this now, this is the path that can go forward. Alternatively, we can go here. And so it's not an A versus B. I understand that nuance, but the decision to indict you either indict or you don't. If you don't indict, it's for any number of reasons. If under these circumstances, the choices that are available are you have a case that's been brought in, taken in from, the state. You can decline it, send it back to the state, make it go away, whatever. Right. We're not interested. You can indict, or indict. You can indict and go to trial. These are the subcategories. Or you can indict and have the defendant plead to the indictment. Or you can indict and work a post-indictment plea deal, which raises the issue you talked about. Or you can negotiate or you can charge, proceed by complaint, and do as Redacted was suggesting. Right. Work a pre-indictment but post-charge disposition. Or you can work a pre-charge disposition, right? I mean, that's really... So that's the parade of possibilities. Sure, but there's more than indictment or don't indict, or indict. That's 6 or 7 options. I understand that. That's how it will play out. But the decision as to whether to indict is binary. You're either indicting or you're not indicting. The act of indicting is something that either happens or doesn't happen. That's all I'm saying. Sure. Okay? So, what I'm getting at is, with respect to the indictment, so, as you're looking at this case, it sounds as if you're doing sort of one analytical track, which is, what do we do with this case? The other piece of that, and a track that could have been followed exclusively, is, what do we need to do to get an indictment that is legally sound and evidentiary? Evidentiaries really... evidentiarily solid. Fuck that word! I like to focus on that track. Okay. Because they're not unrelated. Sure. If you never get down the do we have a viable indictment road, that you're not going to be able to do anything in the other, sure, road. So at this point, you had identified, and you and your people had identified some witness, victim witness issues and some legal issues. My question is, were steps being taken to... I used the term address. Right. Let me clarify. With respect to the witnesses, was the FBI and the line attorney, with the assistance perhaps of the grand jury, taking steps to corroborate? Right. Shore up victim witness testimony. Find new victims, find additional evidence, and so on. So taking that in part is helpful. So, with respect to the witness issues, I recall, and Redacted goes into much more detail in her affidavit, but I recall concerns that were communicated to me about, in essence, to sort of summarize my impression or recollection. These girls are young. They're impressionable. They are scared. Will they stand up in court? There's any number of things that could be used against them. Some of them are, and this is uncomfortable, but some of them thought he actually cared for them. And that's not atypical in these cases where they sort of develop thoughts actually saying he did nothing wrong, and because many of them knew one another, how would that all play out? Right. And so, it would be my assumption, particularly given, how much work Redacted was doing on this case, Ms. Redacted was doing on this case, that she, in combination with the FBI, would be pursuing those matters, and looking to develop the evidence and cooperate. And throughout this process, it would have been my assumption and hope that she was continuing to develop the facts, because that can only help. And so as U.S. Attorney, would it indeed have been your expectation? Yes. And the expectation that all those interim supervisors would have been supporting her and encouraging her and guiding her, it would have been, and that's what happens in typical cases. Right. Just because we're having a legal discussion doesn't mean you stop pursuing leads. Alright, let me stick with the evidence piece of that. Yeah, I'm going to keep these. Helpful. Strains going. You got a very detailed accounting reflected in Exhibit 8 from Redacted of the different Jane Does, and there were a lot of them, and there were many counts in the indictment, and many... Okay, that's the end of that file. Many, carefully, each victim was tied to a particular set of criminal activity. In other words, these victims were not lumped in an aggregate sort of formless petri dish. Yes, they were individuals. Redacted had was meeting with them. Indeed, was finding new victims along with the FBI. And they were conducting individualized assessments of the viability of each victim witness. And indeed, Redacted submitted a follow-on PROS memo, a PROS memo addendum in July and another one in September, and continued to tailor her proposed indictment, to these individualized acts. The question, when I hear the victims referred to in the aggregate, I wonder what effort there was to sit down and address each individual victim, because there were so many, and a credibility issue that could be very troubling with one victim, or 2 victims or 4 victims, fair, could well be overcome by other victims who had not these credibility issues, perhaps others, and if I may finish, that in the aggregate, when presented individually in total, a kind of a persuasive case could be made that would be impossible with 1 or 2 or 3. Is that a fair? So that is fair, and I think, and your point that we shouldn't sort of talk about the victims in aggregate is a fair point. I would respond, and Ms. Redacted goes into this in her affidavit a little bit, and I've got it, and I have a recollection of some discussion of this between myself, and you're going to ask me who, so let me just say I don't know who. But the concern is when you have victims that know one another, to what extent would defense, even if you got 2 victims that say A happened, even if it's similar sets of facts, and another victim that said he did nothing wrong, and another victim that said horrendous things happened, to what extent does defense cast this as they are trying to recover, they're trying to do? And so one of the concerns was when you have victims that know one another, that brought one another in, even if you've got similar patterns, if some of them cast doubt, how would that be taken by the jury? Is that assessment or analysis your own, or is it one that you developed with the people you talked to about this case? So that assessment would have been in my general recollection, but also based on my practice, that kind of witness assessment is the kind of thing that I would have relied more on the ORSA, on my management team for, because that was more within their area of expertise. Right, and Redacted in particular was known as a trial attorney. Right, correct? Right. Do you recall having discussions with Redacted about that? He would have been the logical, right, person. I know that we had those discussions and we talked about what happened. How will they play out at trial? And the takeaway was, it could play out well, it could not play out well. So, as of the time that all And again, I say they as a collective. Right. Understanding that some would say exonerating things. Some would have contradictory statements. Some may not want to testify. And so that conversation was had. You and Redacted talked about it? I can't say. Redacted and I can say. I recall the discussion, I don't know, 12 years ago? You might recall a discussion from 12 years ago. What you presented to me, for the record, I'm pointed to Redacted, or I'm indicating Redacted. The issue about civil rights, do you recall who else was in the room, or wasn't in the room at the time? It's a rhetorical question. We'll take it, I guess. But, yes. One can remember substance without remembering who was in the room at the time. And understanding, right, that this was one case of thousands that were under your, correct, authority, although a particularly sensitive and high-profile one. But the question to you is, do you know what individualized assessment Redacted did of the victim witnesses? I can't speak to that. Do you know whether he actually met with any of the victim witnesses? I can't speak to that. Do you know whether Redacted went to West Palm and sat down and actually went through the evidence as to each one of the potential witnesses? I can't speak to that. Do you know any of that information as to Redacted? Again, I can't. I can't speak to that. I would say that Redacted was first assistant, and to the extent he relied on the criminal chief, he used to be criminal chief, and so, right, he would naturally view the role of criminal chief as being important, and someone that would naturally review matters before they went to the first assistant. I'm trying to find a good point to stop, to be honest. Okay, so when you were, as you recall, having these conversations about the victim issues as matter of evidence, you cannot tell us what the basis for Redacted analysis was. I can't. I mean, as a general matter, I don't recall this specific. As a general matter, when I talk to individuals about a case, I would assume that they had informed themselves and had done the diligence necessary to have that discussion with me. Do you remember him passing out for you, or I don't recall that. The individual, that level of granularity. All right. To finish my sentence, to the individual witnesses, and you're saying you don't, yeah. And by witness, I mean victim witness. Did you ever sit down with Redacted and have her present to you each witness, each victim as a potential witness, and her individualized credibility issues, and how as a prosecutor and an experienced trial attorney, Redacted was going to overcome those issues? I don't recall doing that, and as a matter of general practice, particularly when it came to what I'll call trial issues, we had really experienced individuals in the office, and that's not something that I would typically do on this or other high-profile cases, because they're the trial lawyers. This is what they do. I would tend to focus more on the legal issues. All right, I want to stay with the witness issues and the evidence of that for the moment. In Exhibit 3, this lively exchange between Redacted and Redacted. She asks to make a presentation to you in the last major paragraph of her email on page 4. She says, I would like to make a presentation to the U.S. Attorney, Redacted, and you, with our side of the... Redacted, and you, with our side of the investigation and a revised indictment. The presentation will address the points raised by Epstein's counsel and will convince you of the strength of the case. Bearing in mind that by this time Redacted and Redacted had in front of them, right, her pros memo, her proposed indictment, this analysis she did as evidenced in Exhibit 8, but also the submissions from Jeffrey Lefcourt, and that Redacted had not had a chance to actually make a presentation to them. Redacted's response is on page 3, his last paragraph. He chides Redacted and tells her that you may not dictate the dates and people you will meet with about this or any other case. If the U.S. Attorney or the First Assistant desire to meet with you, they will let you know. She, in her final response on page 1, points out that she's not trying to dictate anything. She's just asking. Are you aware that... Bear in mind you didn't see... Correct. Exhibit 3. Were you aware that Redacted very much wanted to make a presentation to you and to Redacted and Redacted about her case and her evidence? So, I don't recall this. By this you mean, I don't recall being aware of this request. All right. As a general matter, it seemed that there was communications going back and forth, and so she certainly felt comfortable emailing me when she wanted to. I guess is my point, rightly or wrongly. And so I wasn't aware of that request, and so are you suggesting that she could easily have emailed you and said, Alex, I really want to make a presentation to you? I'm not suggesting. What I'm suggesting is from my perspective. There was a lot of communication in this case, more than is typical. I don't recall the request, but there was communication in this case. What do you mean by communication? I mean, there are a lot of emails, but there are a lot of emails, right? But a lot of them are because there are draft. There are draft. Later on we have drafts and so on, but we don't. So what I mean by that is, I do not recall an impression that she didn't have access or wasn't being heard. To you? Correct. You've already seen 2 emails here, where she was scolded pretty seriously, and in one case for approaching, correct. Redacted, and you without Redacted being involved back when, correct. Redacted was Crim Chief. And then here, what Redacted says to her is quite strong, isn't it? Would you have ever used that language to a subordinate? You've seen my emails and my style. I think not. So, what I am saying is, from my perspective at the time, to the best of my recollection, this was not a case where she was frozen out. This was a case where there was ample communication. Mr. Redacted. Well, by Miss Redacted. Did Redacted ever tell you, hey boss, this line assistant, she's been a pain. You know, she's asked to make a presentation to you. She's asked to make a presentation to you. Do you want to do it? I don't. Look, this is 12 years ago. I don't recall it. Whether he did or not, I can't say, but I don't recall it. If he or Redacted, or even Redacted, had directly asked you for that opportunity, would you have entertained it? Would you have agreed to a presentation from the line attorney? As a general matter, if someone makes a direct, saying, this is a case that I have worked, I need to sit down and talk to you, I would have said yes. Do you recall any occasion when a line assistant on his or her own initiative came to you and made such a request and you granted it? I don't, because it rarely got to that level. From my impression and my recollection, we had pretty good communications in the office. Alright, I'm sorry, Miss Redacted. That's okay. Miss Redacted. Cut you off. By Miss Redacted. You've talked about needing to respect the chain of command. Right. Would there have been any repercussions for a line assistant actually trying to approach you about this presentation? I would hope not. I mean, I think it's important for line assistants to be respectful and to, let their supervisor know. And issues, and to do it with respect and not go around supervisors. But I would hope, not. If she had raised it with a supervisor first and her supervisor said, no, that's not your place, would you have expected her to have followed what the supervisor had told her on that regard? Fair point. I'm not aware of this email. I can't speak to that. As a general matter, I would, going back to where I started, I would at 6 o'clock walk around the office and say, how are things going? What case are you working on? In part because I thought it was important to... By Miss Redacted. Did you wander up and down, up to West Palm and do that too? Less often, but yes. By Mr. Redacted. You talked a little bit about the experience of your senior staff. Right. What do you know about the experience Redacted had in handling these types of cases? When you say these types, you mean sex crimes. I can't. Cases involving children. I can't. Or child victims. I can't speak to that. I don't know. What about Redacted? I can't speak to that. Or Redacted? I can't speak to that. By Miss Redacted. But you do know that Redacted had substantial experience with child sex crimes? You named her PSA coordinator. I know that she had experience with prior cases. Alright, yeah. Okay, we're going to go for half an hour more, and then we'll take our break. And then come back. And we will get back to that other piece of the evidence and the legal issues. Right. And then we'll spend a lot of time on the alternatives. Haven't forgotten that. In June of 2007, there was a meeting that Defense Counsel requested of the sort of next level up from Redacted. In other words, they had already made a presentation to the line assistant and her supervisor. They wanted to come to Miami and talk to, in this case, Redacted and Redacted. And they did meet with them. Were you aware? Do you have a recollection of whether you were aware that was there such a meeting? So I don't have a recollection, but it rings a bell. I don't know if that distinction is a fair one. Well, I may help amplify the bell a little bit. One of the defense attorneys who was present there, in addition to Gerald Lefcourt, Roy Black, and Linian Sanchez, was Alan Dershowitz. Oh, that name comes up a lot. Yeah. Does that ring a bell? So it does. Okay. I can't say it's a recollection, but it sounds like there. It sounds right, and in my usual course, once Redacted was meeting with someone, he would typically have let me know. All right. And where would such a meeting take place? Would it be in Redacted office? Was it big enough? Or would you use the executive conference room? Based on the number of people, almost definitely the executive conference room. And do people have to go by your office to get there?
They do not.
Okay. And would you, in a case like this, as you said a moment ago, pop your head in? Right. And say hello? Right. As a typical matter, I probably would not, because then it very rapidly turns into a meeting with me as opposed to a meeting with okay, if that makes sense. There were some written submissions also submitted. Pretty substantial ones. These addressing more of the legal issues. Both before and after this. Did someone, and if so, who, brief you about what happened at the meeting, and what was contained in the written submissions? So, I do not recall a briefing. I would assume that, again, based on practice, there's a senior level meeting in the office. Based on practice, Redacted would have told me, and then afterwards, he would have said this is what happened. Alright, but you have no actual recollection of what happened in this case. I have no actual recollection of, other than the meeting sounding familiar, I have no recollection. So, Exhibit 50 in this packet is almost at the end. It's the next to last, really. Is a letter that Redacted offered to the DAG. The then DAG. Yes. In June of 2008, a whole year later. The DAG, Defense Attorney General Mark Phillip, and this is... You certainly recall that there was an appeal, if you will, a small appeal to the DAG's office. Right. By Defense Counsel, and Redacted submitted a fairly substantial recounting of what had gone before in the case. And he also submitted a number of other documents relative to that. He says on page 3 that at this June 27, 2007 meeting, which he characterized his arguments, legal and factual, were presented against a federal indictment, and Redacted writes that the arguments and written materials provided by the defense were examined by the STFL and rejected. Is that consistent with any understanding you have of what happened at this meeting? So, I don't recall. So I'm going to speculate. And the speculation is that by the time this happened, we were fairly far along in how we were viewing this matter. This being 2008 or... No, June. June 27, 2007. Okay. And as I reviewed the documents, I tried to establish a timeline. But clearly, by July 31st, we had sort of concluded how we were approaching it. And so I'm going to speculate that when he said the arguments and written materials provided to Defense Counsel were examined by the STFL and rejected, it was they asking us to drop the matter. And we said, we're not dropping the matter. Okay. And by the way, just to clean this up, this letter was, to the DAG, was signed by Redacted under your type name, as is, right. Standard, but you're not CC'd on it. Do you recall why you didn't sign this letter? Why was it sent by Redacted? Redacted? I do not recall. That's a point of interest, and so I'll draw your attention to, alright, Exhibit 49, which is actually dated the day prior, that is, June 2nd, 2008, and this is an email to you from Redacted, who was and is the ethics, yes, officer for the U.S. Attorney's Office, correct? Reporting back to you an assessment by the Executive Office of U.S. Attorneys General, Counsel's Office, that they did not see you as having an either actual or apparent conflict of interest that would necessitate your recusal from the Epstein matter by virtue of the fact that you according to this, intended to seek employment with Harvard Law School. Right, or was considering seeking. Was considering, alright. Right. Should you seek employment, it says. So, is it reasonable for us to infer that this potential recusal, right, was pending at the time the letter to Mark Phillip was being drafted, and that's why it went out over a redacted signature, and without you as a CC. So I would not infer that. Okay. In part because it was potential, and in part because Redacted had the facts at his disposal, and was the natural... This was a very detailed letter. I did not feel that... I'm speculating here. As a general matter, things don't have to go out under my name, and some letters went out under his name, and some letters went out under my name, and the ones that went out under my name tended to be ones that I had more authorship in, and the ones that went out under his name, in this case, were the ones that he had more authorship in. And so I would just say that this was the continuing course of that. Okay, thank you. Minor technical issue. By Ms. Redacted. Would you have read the letter before it went out? Probably. I would say in my usual course he would have shown it to me, but not always. Not always letters that would have been sent to the Deputy Attorney General's office, or just letters in general. Well, he would have. I think he would have shown this to me because it's going to the Deputy's office. The flip side is I trust Redacted. I think he's a professional. So, an important distinction to draw. I remember talking to a Orsa that has spent time at Main Justice, and contrasting the experience of an Orsa with the experience of a trial lawyer here, And sort of the line was, you can't send a letter from the main justice without 3 letters of approval, whereas an author in their case typically doesn't even get approval from their line supervisor. And so as a usual matter, particularly in this case, Redacted would run letters by me. That doesn't mean that every letter had to be run by me, and I was certainly aware that the letter was being transmitted. I was aware of the appeal to DC. I comforted him what we had done, and so I thought the appeal would be fine, and if I was out of the office, or if there was some reason that I wasn't going to be consulted, Redacted was quite capable of doing it without my review.
Hello, you two. You alright? I had a sneeze. I didn't even notice. We have cats. One above, Dexter's at top, and Clara is a cushion underneath.
Where the fuck was I? Leader in preparation for... I did. This, and is there anything in it that in your view is not accurate? I think is accurate. I think the letter, as it should be, is a advocacy piece for what the office had done as opposed to a, on the other hand, an analysis piece. But at this point we're defending the actions of the office, and I think it appropriately should be an advocacy piece. Hello, Clara. Alright. Do you disagree with any of the points of advocacy, or the points made in advocacy?
Clara, you're in the way of my piece of my... Okay. She's standing right in front of my monitor.
Oh no, she's lying down. There's a good girl.
They've been mostly good. They've been chilling out and sleeping most of the time. So I'm going to try and get to page 200, ideally. I can feel my voice break. I reckon I can keep going for a little bit. I feel my voice breaking, and because I want to enjoy my weekend a little bit, and so I want to get a good night's sleep. And I need to do a little bit of last tinkering work behind the scenes of a few videos. So I'll carry on from this, line 19. All right. Oh no, hang on. Yes, okay. Alright, do you disagree with any of the points of advocacy, or the points made in advocacy? We'd have to go through it. Alright, paragraph by paragraph. Okay. But nothing struck you so much that you, I think, recall? I think he fairly presented the totality of everything to the DAG, or DAG, for the DAG to review her for whoever the DAG designated, and I think that was an appropriate presentation. Alright, thank you. So now I'd like to launch into... And before we break for lunch, sort of the core question, which we addressed a little bit earlier, and that is, who at the US Attorney's Office made the decision to resolve this case with an offer of a 2-year state plea, and why? Right. So how we got to the 2 years, I can't tell you, because I can give you my general impression. Ultimately, all the cases in the US Attorney's Office were under me. Ultimately, I saw what we will call that, 3-pronged resolution. 2 years, registration and restitution, and ultimately that was approved on my authority. So, who came... Did you come up with it? Was it your idea? Of an issue? I don't know. This is reconstructing conversations. I'm going to speculate now. This was not... Let's all get in a room and figure out the resolution in the next half hour. But this was a course as things are discussed, and there's a back and forth over the course of some days or a week or two, and then people get together and discuss, and a view develops, and then the office proceeds with that. Clara, that's not a good place to be. That is not a good place to be.
Let's get you up. There's a good girl.
You're alright. You're alright.
It's okay. Let's just place you here. Hey,
come sit here. No. Not on the keyboard. Not on the mouse.
Okay. If you just lie down, stay cool, you can stay there. There's a good girl.
Yeah, or you can sit on the arm as well if you want. Okay. But this was, of course, as things are discussed, and there's a back and forth over the course of some days or a week or two, and then people get together and discuss, and a view develops, and then the office proceeds with that. But ultimately, let me just sort of push back. Look, ultimately, I approved it, and so okay, accept that. I'm not pushing away responsibility for it. I'm just saying I can't recall how we got to, for example, 2 years. I can speculate as to particular parts of it, but I can't, but ultimately I'm not pushing away responsibility. I understand, and we're going to delve into that.
Right. That 2 years. Shortly. But I want to turn back to exhibit number 3, in which sort of the statement that launches this, what I keep calling a lively exchange, is on page 4, the statement from Redacted, and this is in response to an inquiry from Redacted to her management, not including you, about what conversations any of them has had with defense counsel. Right. About any resolution, because her plan was to talk to Lilian Sanchez about working a plea to federal time concurrent to the state, whatever the state time was. And in response, Redacted tells her, I told Lily that her state plea with jail time and sex offender status may satisfy the USA, meaning the US attorney. Right. I believe. So that's a close quote after USA. Had he discussed that with you?
Hey. No scratching. No ruining my carpet. Clara, come here. Yeah. Clara's lifting up the carpet in the corner of my room, and I don't want her to do that because, that carpet came with the house and it's only a year old.
Right, I believe. So that's a close quote after USA. Had he discussed that with you? How did he know that it might satisfy you?
I told you no. Am I going to have to put you out? You leave that bit alone. Hello. Wait, let's get you up. It's okay. Hey, you can stay here. No, and you're going back to the same place. Okay. Well, if you do that again, you're out the room. Okay? Clara's a gremlin. Dexter's the good one. Okay.
Had he discussed that with you? How did he know that might satisfy you? So, I don't recall. I can speculate based on Mr. Redacted's course of conduct. I don't think he would have raised that possibility in case of this profile without having discussed it with me. But you have no I have no specific recollection, but I don't think he would have done that without having come by and said. Alright. At this point, bearing in mind that you don't have any specific recollection, do you believe you had any understanding of what amount of jail time was in play at this point when Redacted tells Lilian Sanchez? I can't pinpoint that timeline. Alright, to that degree. Alright, of accuracy. He also says later in this email that he told this to Lilian Sanchez a couple of weeks prior, before the June 26th meeting. Correct. Alright. Were you aware that Redacted had been communicating directly with Sanchez about the case?
Clara, stop it.
I'll tell you what, I've got a better idea.
There you go. Can't tear up the carpet if I chuck a pair of jeans on there. She's right back to it. Jesus. That's a very misbehaving cat. Whenever she's not sleeping or cuddling up with me, she likes to cause some mischief. Anyway. Fuck. Well, I think if they keep doing this and they keep distracting me, I might not be able to make it to 200 pages. I want to try. Okay. I think it was here. He also says later in this email that he told this to Lilian Sanchez a couple of weeks prior, before the June 26th meeting. For fuck's sake, Clara. Out you go. Out you go. You're misbehaving. Out. Out. Or you can sit there. Or you're out. I don't want to get them both out because Dexter's still chilling up there and he's absolutely fine. It's just Clara keeps trying to tear up the carpet. But trouble is, if she keeps doing this, I'm going to have to kick her out because she's distracted me too much. Okay. He also says later in this email that he told this to Lilian Sanchez a couple of weeks prior before the June 26th meeting. Correct. Alright. Were you aware that Redacted had been communicating directly with Sanchez about the case, and specifically that he represented that you might go for a state disposition if it included jail time and sex offender registration? I don't recall whether I was aware or not. I recall at some point adopting the concept of jail time plus registration, and then plus restitution. And also, I don't know when that would have happened. Let me also speculate that the US attorney might go,
Could also refer to, this is being talked about. No final decision has been made.
Oh, she's right back there. Out, 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 out. Out, out, out. A foot of encouragement maybe is needed. Fuck's sake, cat. Right. I'll let her back in when she's calmed down. She's got the rest of the house to play around with, and Dexter is just happy chilling there. He better not open that fucking door. I think they know how to open the doors of my house now, which is a bit scary. As long as they don't open the outside ones, though, that's fine. Let's see. And I'll come from here. And so I don't know when that would have happened. Let me also speculate that the US attorney might go, could also refer to, this is being talked about. No final decision has been made. Right. If Redacted had made that informal discussion comment to Lilian Sanchez without having told you, without having gotten your clearance ahead of time to tell her that, would that surprise you? Or would you have expected him to consult with you about whether it was okay to go ahead and raise this? So, as a general matter, yes, but... And let me explain that. Horses, on occasion, and because this is a higher profile case, a criminal chief may run an idea across opposing counsel and say, look, I don't have authorization. I don't know how the office will react, but it's certainly possible that X, Y, or Z may work out, and that's a very different conversation than, the office will accept. And so a lot of that really depends on how that conversation goes, and, certainly if he's representing my view. I would expect him to check on what my view is, and he's, as criminal chief, saying, this is something that I could support. I don't know how the office will react, that may, but I can run it up the flagpole. That might be a different type of conversation. Hello, Dexter. Okay, and did you know Lilian Sanchez? I did. She was an author in the office. And she left about a month after you came on board. Was it that quick? That's our information, yes. Okay. Although she apparently remained a periodic present. Hence, the wasn't that quick. Did you know that she'd been redacted deputy at major crimes? I don't remember that. Alright. What did you remember about that, Dexter? Don't attack my mic. What did you remember about her? And had you had any dealings with her after she left the office up to this point? So I remember that she was in the office, that she was a senior attorney. Whether within the management structure or not, I didn't recollect until you just raised it, and that I can't swear to it, but it rings a bell that she was in major crimes, and she was someone that you would see at bar functions that would... She was active in the local bar, and I would see her on occasion at a bar function and say hello. Alright. Did you encounter her in connection with a case? Stop attacking my mic. To your recollection, in the period before Epstein? I'm hesitating not to avoid, but I'm running through my... Not that I recall. What's your impression of her as a practitioner? She did quite well after she left the office. I think she set up her own practice. At this time, she was with something called Fowler White Burnett. Okay, so she went to Fowler White. Subsequently, she set up her own practice, and I thought she'd done well for herself. Okay. Were you aware that Redacted had a close personal relationship with Lilian Sanchez? Both because... Out the way, Dex. Both because they had worked together as chief and deputy chief. In major crimes, but also because they'd had a dating relationship sometime prior. I don't recall them having dated, but I don't... Do you recall knowing that they had dated in the past? I don't recall knowing that, and in all candor, that's not the kind of thing I ask about. But in this case, with her representation of somebody in a matter being ultimately supervised by Redacted, would you have expected Redacted to disclose to you that he'd had a prior romantic relationship with Lilian Sanchez, a member of Epstein's defense team, if only to address a potential appearance of impropriety or conflict of interest? I think some of that might have depended on how recently. Was it 10 years ago? Was it 2 years ago? If they were in the supervisory chain that this happened, that could raise other issues. So for example, Redacted disclosed to me a potential conflict. To the extent that these arise, if there is a potential conflict, I'd like to know. I was aware of Redacted conflict. I said, keep going. And in fact, Redacted, you're talking about the Herman, yes. Connection. The prior, yes. Short-lived law firm connection.
Are you aware that Redacted in fact vetted that through Redacted, your ethics person? I am. I don't recall that independently, but I recall knowing about it. He may have told me he vetted it through Redacted. Redacted is highly respected in the office, and that would be the appropriate. So, are you also aware that Redacted raised, again with Redacted, the potential again appearance of a conflict of interest, or appearance of impropriety? Because of his supervision of the Epstein case and his concurrent close relationship with Mike Tyne, who was an attorney who was representing Epstein, as well as Guy Lewis, a former US attorney. So, I was not aware of that. You were not aware of it, but I guess what I'm noting is that both Redacted and Redacted perceived appearance issues. I went through the process that's provided for them to get the blessing to go ahead and proceed with the case by the blessing by the ethics expert. Right. But Redacted apparently did not in this case, via vis-a-vis Lily Ann Sanchez. Yeah. Does that surprise you or disappoint you or perplex you or do you care? I would want to know more. Right. But certainly it would provide... I would want to know more before saying I'm disappointed, but again, was it 10 years ago? Was it 2 years ago? What's the continuing... There are a lot of facts, but certainly it's the kind of discussion one would typically have with Redacted. And in this case, what we're talking about is an informal conversation, or informal discussion, to use Redacted's own term, with Sanchez, as opposed to any of the other attorneys in Epstein's team, about a particular resolution that we're going to spend all afternoon talking about, because it has some problematic aspects. Okay? So, you see why I get it. No, I get it. Okay. By Mr. Redacted. So before we break, should you have talked about this potential resolution with the line assistant before actually making it? In a typical case, yes. So in a typical case, I foster communication. I get involved in cases, but we want to know what the line assistant thinks. And they can agree or disagree, but we want input. By Ms. Redacted. What do you make of this reality acid tone between Redacted and Redacted? Really acid tone between Redacted and Redacted. Between Redacted and Redacted in his Exhibit 3 exchange. I mean, Redacted is really, as I read it, is pretty strong. I'm not sure what to make of it. Alright. There are a couple of... Can we go off the record for a split second? Off the record. By Ms. Redacted. Okay, back on the record. Going back to Exhibit number 3, there are a few things here that we think are important to raise with you, albeit you not having seen this at the time. Redacted says that she complains about this soft, that's my term, plea offer that Redacted extended to Epstein through Lily Ann Sanchez. She says that such an offer is completely unacceptable to the FBI, ICE, the victims, and me, meaning Redacted. Did you have an understanding of what the FBI's position about prosecuting this case was? My recollection of interaction with the FBI is with Redacted, who was the SAC, and as I recall he supported the eventual direction of this case. Is he the individual who you identify, I believe in actually your attorney's written response as the SAC who called you to congratulate you about the case? About the result? Yes. And was SAC Redacted, in that same written response from your attorney, there's a mention that he was present at many meetings on this case. He was present at least some, and in part, that was at my request, because this was a high enough profile case that I wanted to bring him into this. So, we know he was present at the December 14th, 2007 meeting, right? Yeah. With Ken Starr and company. He is not present according to our investigation, at any other case with defense counsel. Others are. His ASAC, Redacted is present. So, recollections aren't nearly as good as documents. I don't recall the December meeting. I would have said that he was present at the September meeting, but it may be that I am, because this was so long ago, mixing the two. Okay. Because I thought he would have come to the September meeting. No, according to all the information we have, just so you know, right. Redacted was there as ASAC, but not... Actually, I'm not sure she was at any rate, she was... Right. He was present. Redacted was present at the December meeting only. Right. So, just so fair. Okay. Would he have been present at meetings other than with defense counsel meetings about this case? Typically, no. Typically, he and I would have talked on the phone or had discussion, and I know that he was aware of the matter. So, I've always been aware of the matter and generally positive as to the direction that we were going. By the direction of the eventual outcome? The eventual outcome. Alright, so what about the prosecution? Do you know what the FBI's view was about the prosecution? I can't speak to the timeline. I would have, and I'm contradicting the documents here, but I would have, if you had asked me, he said he was present at the September meeting and was aware of the terms that were presented at the September meeting. Clearly I'm right. My recollection is incorrect, and I take that for what it is. Just to finish on, with this point, though, my question was an understanding of the FBI's position of the case, not the ultimate disposition. In other words, as of the date of Exhibit 3, there was no deal on the table. So the question is, what was the FBI's view about the case? So I'm not trying to be difficult. At some point, when you say view, the FBI, to my recollection, thought that what Mr. Epstein did was sordid and disgusting, and that we should proceed. How we proceeded, I don't recall hearing specific views as to the how, as opposed to the we should. All right, thank you. Let's take a break. 45 minutes. Thank you. Off the record. I'm tempted to call it here and sort of split this whole thing into like thirds or something. Because I'm getting tired and my voice is breaking. I'm stumbling over my words a lot. So I think I will be taking advantage of that opportunity. It's been 2.5 hours. As I say, I want to get some good sleep. But we have done 134 pages. So that's almost a third, I want to say. Almost a third, give or take. But this is a natural place to break, because this is when they take a break. And by break, I mean I might end up doing it tomorrow. But anyway, apparently I've got 0 viewers anyway, so that's fine. So yeah, thank you very much, ladies and gentlemen. We will continue from here. I'll aim to do that as soon as possible. And I will tie these things all together. I'll clip all of this stuff and we'll release it as one big video, just so we can have the entirety of this interview, because I think it's very interesting. I think one of the big questions was, they knew about him for so long. Why did it take so long, and why was he allowed to continue doing what he did? This answers a lot of those questions, so I will absolutely be clipping this. Anyway, I have one kitty here, but one kitty outside to take care of. Make sure they're not in any trouble. Oh, hello, Dexter. And as I say, a few backroom stuff, and I'm going to enjoy my weekend. But I might also stream during the weekend as well. Oh, who knows? It depends on what happens. Anyway, ladies and gents, it's been fun once again, and I'll see you guys next time. Bye for now.